Yes, please. We can't keep waiting. We'll adjourn it and have it after view. Who is arguing your case?
He will argue for one, Learned Senior Counsel Ken Chaudhary, and I am for rest of this.
Rashid Advocate General is here. Rashid will be here. Rashid is on his way.
May it please your lordship.
Yes.
So other day I was placing the impugned judgment. I carried up to 174
Yes.
case number. So may I continue from paragraph 174?
You know, arrange it signally. Something will be done. Signally.
174.
Can you just tag it up?
Yes. It will be page
174.
174, page 145 in the memo of appeal.
Yes.
Now coming back to the instant case, accordingly on 30/6/2021, the learned so-and-so appeared on behalf of NIA. In this case, the prosecution has argued on the case regarding the charge over a period of almost 3 months, from 16/3 to 10/6. Thereafter, the defense completed the argument on 24/6/2021, as already mentioned. Considering the long period of time for which the matter has been pending at the stage of charge hearing, the learned prosecution advocate general representing the prosecution and Bor Thakur Learned Defense Counsel were requested to submit and complete their reply and arguments, if any, on the additional materials comprising just one relevant photo and statement on 30/6/2021 itself, so that the order on the point of charge can be passed expeditiously without further delay, as the same has been pending for long and one accused is an UTP, and if charge is framed, the case can be taken up to the next stage. Moreover, long pendency of this case at the stage of charge hearing has delayed pending charge hearing of the other NIA matters in this court, in which accused persons are in custody. The Learned Defense Counsel submitted that they had just support the written objection filed by them. Till that moment, we have not received a copy of it. On the other hand, the prosecution sought an adjournment seeking 10 days time. It may be mentioned herein that the date was fixed on 30th June 2021 on the prayer of the prosecution as stated in para above. The court considered that the said prayer was not justified in the backdrop of the aforesaid facts and circumstances. In this case, NIA and the prosecution have availed sufficient time for investigation and charge hearing respectively. It may be mentioned herein that the charge was filed on 29/5/2020 itself. Therefore, the court was of the considered view that in the interest of justice, there should be any more delay whatsoever on the part of the prosecution or defense, even with regard to the additional charge sheet, and that arguments, if any, on the same should have been addressed promptly. The court was not willing to countenance any possible delaying tactic. This is what is troubling us, Lordship. Was it delaying tactic on our part? The previous day, we submitted the additional charge sheet. Whether they have received it or not, we do not know. Whether it is accepted by the court or not, we do not know. 2 other applications were filed prior to that. Those were not ordered. And the learned trial just found that there is a possibility of a delaying tactic on our part. And every day things were happening on the part of the prosecution in the interest of justice.
Previous day, that is 29.
29, we submitted the additional charge sheet with a prayer for accepting the same. We do not know the fate of that application. the prior date, Lordship, on 28, we submitted another application for keeping secrecy of the identity of the protected witness C under section 17 of the NIA. That was also not ordered. Accordingly, the
Just 1 minute.
yes, Lord. Section 17, NIA or NIA? These are all part of the records, Lordship.
No order was passed on the additional charge sheet.
Later on, when on first, this order was passed, along with that date, he passed backdated orders. I have placed those orders on 28th and 29th. All those orders were shown to be passed. But at the time of 30th, when the hearing for adjournment was going on, the learned trial judge himself said that I have not passed any order. And the learned trial judge also said that, did not say anything that an objection has forthcoming from the other side. Later on, it was said that on 29th, they have filed a written objection to our additional search sheet.
Same day.
Same day.
And 28, you filed application for what?
For under section 17 for secrecy of the identity of the protected. These are all part of the records, Lordship. These applications and the orders also. In our memo of appeal also, we have annexed everything. On 30th, we filed the additional search sheet with a prayer for accepting the same. No order was passed
Which
on.
page these orders are there, which according to you were passed backdated?
The two orders which I have placed, I'll just, the other day I placed, I'll just.
Just give the page number, that will be fine.
332 and 333 and 34.
333 and 334.
Yeah, and 332. 28th order is on 332
Hmm.
and 29th order is on 333 and 334. And 30th order for rejection of the adjournment application, Lordship, that is on 335 to 339. All these orders where we have come to know only on first, when the accused were discharged. But on that day, we received this 100 and how many pages, Lordship? It is a very long order. We received everything. 160-page judgment.
Yes.
The court was not willing to countenance any possible delaying tactic on the part of the prosecution in the interest of justice. Accordingly, the prosecution prayer for adjournment was rejected by the order dated 36/2021, and the case was fixed for orders on the point of charge. Analysis of materials and findings thereon with regard to the point of charge. Whatever was stated by PwC has been stated in paragraph 75 to then 176 is the photograph D91 of the accused number 1 imparting some training in a jungle in Uri, Jharkhand. And 128 now 177 also some descriptions. 178 now. We did not get any opportunity to argue. Although the learned trial judge has said that on 30th, when we are praying for adjournment, he made a request for us to argue on the additional search sheet. That is a totally incorrect statement, Lordship, which was recorded in the order. Nobody went to that stage. Everybody was concerned about what will be the next date of hearing. So that observation and that statement of the learned trial judge in the order, in my humble submission with utmost humility, I am saying, it was never discussed, never argued, never contended by any side. And never The Honorable Court also directed us to do so. With utmost humility, I am submitting, Lordship. This is after all a temple of justice. 178. However, with regard to those allegations, if the police of the state or any appropriate investigating authority having jurisdiction find them to be verifiable facts meriting an investigation, they can always pursue the due process of law.
No, you're
This is
reading from page number?
Page 149, paragraph 178. While the learned trial judge analyzed the additional materials, that is additional search sheet and the photograph. Now, 178 says, however, with regard to these allegations, if the police of the state or any appropriate investigating authority having jurisdiction find them to be verifiable facts meriting an investigation, they can always pursue with due process of law. This is precisely what we have done by the NIA. Why further investigation is required? We found a photograph. He was imparting training in the jungle of Jharkhand. We place it as document number 91. In the additional searches, all were corroborated. There is additional witness also. We have done that. Now the learned trial just says, if these are verifiable facts, you go for an investigation. Arey Baba, we have already completed the investigation and submitted it to you. If it is not acceptable, a reasonable order may be passed. As regard to the statement of PwC, the allegations therein have no correlation with the charge sheeted section so and so, so and so. Fine, but where is our submission on that? We have to argue. We will try to satisfy. Today we are arguing before this honorable. We are trying to satisfy our case before this honorable court. But where is that opportunity? So submitting a document and on the basis of that document, the honorable court can pass. Then for that, no hearing is required. But that is not permissible. Let me place section 227 and 228 of the CRPC. Section 227 says, discharge. 227, may I read it, Lordship? But language is very clear. If upon consideration of the records of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf. So after hearing the submission, where is our submission on those documents? The judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. So on these additional documents, neither we nor the other side got an opportunity.
Additional charge sheet, you mean?
Additional charge sheet as well as the additional document. How that objection came, that is a mystery to us on the 29th evening. On 30th, it was neither disclosed by the defense side nor by the honorable judge to us. But in the order we found, that an objection has come. Otherwise, my submission would have been at the time of hearing that I have just received that objection. Let me go through it because till that time it was unknown to us.
When was the objection filed as per record? Is it there?
I think it is on 29th because we submitted it on 29th.
Mr. Chaudhary, was an objection filed by your client?
Yes. On
When-
29th itself, your lordship, we have filed immediately on getting it. We filed it, right?
Where is the objection? Is it on record?
It will be on record.
Can you just figure it out? So on 29th, you received a copy of the additional charge sheet. And on 29th, you submitted an objection.
Unpaid objection, your lordship. The learned trial just told us that if you have anything to submit, we say we are submitting our objection, but we leave it to the honorable court to pass an order, and thereafter the learned court below accepted the search.
And the offenses are same,
Within their order.
offenses are same.
Offenses are same.
If any prejudice is caused, thereby it is to the accused, not to the prosecution.
Prejudice is caused to us because our materials were not considered. Accepting is half of the game. What about the other part? To frame the charge. That additional opportunity, it was allowed without hearing us. It is detrimental to them. Suppose a charge was framed on the additional search sheet, then what would have they said? We did not get the opportunity. The rule of the game should be equal to all sides. It should be a level playing game. Thereafter, the allegations made by prosecution witness C proceeds on a trajectory quite different from the factual metrics of the instant case. These are the opinions. We have not argued anything, so all these opinions have no meaning. What is our intention? We have to produce it before the court, and we have to argue in what context, whether it is in context of the provisions of the sections which were charged or not. That is our domain. We will indicate to the Honorable Court that these are the materials to make out a case of section 15, section 18, section 39, section 120B, section 153AB. It is our duty, but that opportunity has not been given. Otherwise, all the cases, one side will file the petition, one side will file the written objection, and the Honorable Court will pass the order. So the stage of hearing should not be there. So the principle of natural justice says the provisions of the statute, section 227 says, after hearing the submission of both the sides, the prosecution as well as the witness, then the judge will come to a conclusion whether those materials are sufficient or insufficient to grant the charge. So I'm not troubling these paragraphs 180, 181, these are all opinions.
All right, now just a moment, Mr. Chaudhary.
Yes.
We are trying to take a reasonable, balanced and practical view in the matter. You see, whether the materials are enough to frame charge or not, that is another matter. Whichever way the court decides, because it is an appellate court, we have to be very circumscribed. But the point is, if the prosecution is saying that they were not given an opportunity to argue their case, particularly after the additional charge sheet was submitted, and it appears that humanly it is not possible. 29 charge sheet is filed, and on 30th, a 120-page judgment is delivered. It will be very difficult for the court to
160 pages.
whatever 120, 160 page. Now, are you really contesting on that part that they were
Exactly,
not-
my lord. I'm doing. My lord, mere saying there are materials will not do. Which is that material which attracts section 15 and 39?
No,
Till
no.
now, they have not produced. Till that, they have not submitted. No, my lord, Lords will kindly see. The law is very clear. The scope of 227, scope of 228 are absolutely clear. And we need not, supplement that because Honorable Supreme Court has already laid it. The only test is whether the materials which finds place in the charge sheet, it can be said that it constitutes the ingredient of the offense. Let them so instead of arguing for 3 days, I think this can be done in 30 minutes. Which material, when my learned friend has tried to correlate the ingredients of the offense and the materials in the charge sheet. End of the matter, my lord. Why should we read the whole thing again and again and again?
No,
No,
followed.
I'm coming to that. Now, let my learned friend also show that the materials which were there in the additional charge sheet was not taken note of by the learned judge below. We are only submitting that he has not taken what he has not taken note of. What according to you should have been taken note of? Where is the argument? My lord, it's a question of liberty of a citizen, my lord. And in the entire state of Assam, crores of people agitated against CAA, they could pick up only one gentleman. Only one gentleman was responsible for all this. No, my lord, things has to be taken in perspective. Your lordships will do the balancing act. I may get swayed away, he may get swayed away, but your lordships will not.
No, Mr. Chaudhary, that's what we're
You know,
trying to do.
entire state hesitated against CAA. They could pick up only one gentleman. Why Asu did not spearhead at the moment? Why you did not pick up Samujjal Bhattacharjee? Why you picked up this gentleman called Gogoi?
Mr. Chaudhary, we appreciate your
No, my lord, these are
concern.
no,
We
my
are
lord,
on a slightly different
no,
issue here.
no, my lord. My submission is very simple. what is the attempt which has been made by the NIA to show that there was infraction of section 227 while rejecting the case and infraction of 228 CRPC while not framing charge? Who are the offenses in respect of which the charge sheet was filed? That's the only point to be decided. And I'll satisfy your lordships, my lord, the learned judge has written a very wonderful judgment rather. I do not know whether I'm competent to say that or not. Eventually it will be
certainly.
decided. He has written a good judgment, my lord. And he has taken, my lord, yes. There could, my lord, in the matter, my lord, if a adjournment is granted or refused, can you allege malafide against the judge? Is it
No,
the
no,
practice we have
that
developed?
we are definitely not
What
accepting.
is that, my lord? A personal attack is being made on the judge for what reason?
He has clarified there is no malafide being
Why not?
included.
Why, my lord, after saying that today again he is making that argument, this was backdated. The moment you say it is backdated, is it worse? It is worse than alleging malafide, my lord. How can you say a judge has passed an order backdated? What is the basis of saying so? And where was the adjournment application filed by them on 30th? Is it not the practice in a trial court, my lord, to file an application paying the court fee? Which is that? Where is that? Where is that? Why is it not annexed? Lord, question of, I mean, making a mountain out of a molehill will not do, my lord. We are in a court of law. We have to satisfy your lordship how the legal requirements were not met with. That's the only argument should be. And I'll satisfy your lordship, my lord. Here is a case, there is absolutely no infirmity. But thereby I'm not saying, my lord, this order is not subject to review.
No,
That is
that-
your lordship's domain.
No, that we appreciate.
No, my lord.
So,
This is not the way, my lord. Again and again, you are attacking the judge. If you are attacking the judge, my lord, NIA has not made a statement in the memo of appeal or in the stay application, alleging malafide against the judge. So whose version is it?
Let-
NIA's version or my learned friend's version? No, my lord, that's a very serious matter. Tomorrow I cannot go to Supreme Court and argue against in a case and allege malafide against a particular judge. I mean, we will assail the order in its merit. Now, how he has gone wrong in exercising judicial discretion in not granting adjournment, that will be a different argument. On the contrary, you are repeatedly, my lord, when you do not have any case on merit, only way to, I mean, try to, that is the way they are
That's
doing
fair,
it.
Mr. Chaudhary.
Yes.
Mr. Saika,
Yes.
we'll request you not to even.
I'm
remotely-
reading, I'm reading here. Whatever I am saying, it is not that it is not pleaded, it is pleaded.
All right, you
What is it?
continue
Yeah.
and we'll hear.
Yes,
you.
Lordship.
Yes.
And shouting will not, we do not want lessons from my senior counsel, how to argue. We don't need permission.
All right, all right.
And why he is taking the name of the student leader of ASU? This is not a political battlefield. Everybody can take utter names. Why Samujjal Bhattacharya's name has been uttered here? He is not a part of the
No, he is
record.
not we are not concerned with anybody else.
Lordship,
We are
that
only
is why.
concerned with the validity of the order.
Exactly, Lord. So
That's all.
I am reading whatever the meaning of these wordings. I'm
Mhm.
trying to emphasize. It is nothing that there is any personal thing or I'm saying something from the air. If
All right, all right.
there is a uttering from the other side that there is no pleadings, I can show the pleadings.
No, you argue and we'll also hear
Yes.
their case
And
completely.
shouting and raising the voice will not scare us.
This is on live streaming, so let us all come together on maintaining the court decorum. That's all. That is a request.
So
from the
now,
court.
paragraph 184, I am reading the judgments.
Yes.
So while just reading the judgments, I am making my submission.
No, Mr. Chaudhary has responded to a query from.
No,
the court.
that is fine. But I am not taking any malafide opinion or anything like that. Had it been a malafide case, we know the law that we have to make the gentleman a party. We are
Right.
not doing that.
Right.
But the thing is that not granting adjournment and in the
So
court,
your point is noted.
Yes.
Your basic submission is that.
this is one line of my argument.
Is-
My arguments on this on the merit
That's
first.
right. Your argument is that
This is the additional argument I am making.
prosecution was not given a fair opportunity to
Exactly.
place its case.
That is what I am saying, that principle of natural justice.
Hmm.
Just giving a hearing is not sufficient. Proper effective hearing should take place.
All right, we have noted that. You may proceed.
Yes. 184, in regard D91, which is a photo identification memo proceeding, where these photos were stated to be identified by the protected witness on 27/6/2021 during identification proceedings conducted on 27/6/2021 at the NIA office at Guwahati. It is stated that in D91, during the said identification proceedings, the identifier PWB stated that A1 probably visited Saranga jungle to meet Maoist leaders to establish link with KMSS cadres. He also stated that the said photograph allegedly of A1 was probably taken at Saranga jungle of Jharkhand. Again, here also PWB does not mention any date, month, year. Thus, it appears prima facie that the identifier himself is vague about whether it is in Saranga jungle or whether A1 went there to meet Maoist. The aspect of lack of resemblance of the naked eye has already been mentioned. There is no indication regarding the date, month, and year of the photo in either photo or the photo identification proceedings. Therefore, even if it is assumed that for a moment that the photo is of A1, the same is grossly inadequate to try A1 under section 39 UAPA. I have found endorsement in the case diary pertaining to these additional materials about some photographs of AWA taken by Maoist camp in 2009, without, however, mentioning any time, date, month of taking photographs in 2009. As already discussed above, the date is important because this organization, CPI Maoist, was banned in law as a terrorist organization only with effect from 22/6/29. Further, if the photo was taken in 2009 as indicated at a place of the case diary, the investigating authority took inordinately long to bring it before the court on 29/6/2021, especially when the identifier of the photo protected witness B was examined by NIA in 6/5/2020. So now pausing here for a moment, whether this date 22/6/2009 has any importance. It organization can become unlawful if a notification is issued by the central government under the provisions of section 3 of the UAPA Act. If my organization, suppose I belong to a particular club, we are involving in lot of terrorist act as per section 15. Will our club members not be responsible? Only because that the central government has not issued the notification under the For that, in 2019, individual is also included, but I am not on individual because the definition of terrorist gang was already there. In 2019, an amendment has been done.
Which section you're referring?
I am just indicating because whatever I am submitting, section 2. Definition subsection EC. Person means person includes an individual, a company, a firm, an organization, association, etc. And this was what it was inserted in August 2019 down below. So then individual is a addition. We are not on that. We are on terrorist gang. (2L). Terrorist gang means an association other than terrorist organization, whether systematic or otherwise, who is concerned with or involved in terrorist act. So if organization or a group of people or an association of people, lordship, if they are involved in terrorist act as defined under section 15, they will also come under the provisions of section 18. So now section 15 says what?
Yes.
Section
You already
15
placed.
I have placed. So in this context, I am submitting because if the opportunity of hearing was given, we would have clarified it.
Okay.
Terrorist act, whoever will include terrorist gang, terrorist organization, individual, firm, company, etc. It is a very wide and expansive word. It is not said that instead of whoever, the terrorist gang would have been there. If it is so narrow, a terrorist organization would have been there. So section 15 encompasses all the persons, whether they belong to a banned organization, non-banned organization, or an individual. So we are not saying that A1 or AB, A2, A3, A4 as individual. They are part of KMSS. They were involved with sending their members to Maoist organization of 2009 or prior to from 2004 onwards, 2004 onwards till 22nd of June 2009, the CPIM Maoist was not a banned organization under Section 3. On 22nd June, it was declared as a banned organization. So prior to that also, it will cover the members who went to Odisha or Jharkhand Lordship. They will come under the definition of terrorist gang. At that means Lordship prior to June 2009, this CPI Maoist organization was a terrorist gang. It was not a terrorist organization under Section 3. Further information comes that at that point of time also in Chhattisgarh and Odisha, it was banned organization, but I am on a national perspective. So this date has no relevancy because this date was taken to be a very relevant aspect by the learned trial judge. So at no point of time, Lordship, the terrorist gang definition was discussed or even it was considered. So when we say whoever does that terrorist act, Lordship, will also include terrorist gang members. Whether KMS is a terrorist gang or CPIM ML or CPIM Maoist is a terrorist gang, that is a different aspect. Then coming to paragraph 190. With regard to the protected witness A, B, and C, it is surprising that while the statements of protected witness A and B have been recorded more than 10 years after the alleged activities, on the other hand, the statement of protected witness C has been recorded after completion of the main charge hearing by both the learned prosecution as well as the learned defense over an extended period. Further, if the photograph number 1 of D91 was taken in 2009, as indicated at a place in the case diary, one fails to understand why the investigating agency took so long to bring it to the court on 29/6/2021, especially when the identifier of the photo protected witness B was examined by NIA on 6/5/2020 itself, as already discussed. The findings in the charge sheet with regard to accused A2, A3, A4 were found by this court to bear almost no correlation to the materials perused. Even with regard to A1, the correlation was found to be non-existent with regard to some sections, and with regard to other sections, the materials were found to be inadequate. Pausing here for a moment once more, Lordship, whether that delay is fatal, because Section 173 very clearly says additional search sheet is permissible.
Section
173 to 3 of the CRPC. Even after that order was passed on 1/7, Lordship, we received the Forensic Science Laboratories report on 7th of July, after 7 days, which certified that the voices were genuine.
So does the impugn order anyway mentions what has happened to the additional charge sheet?
Yes.
Was it
This is
accepted?
what I am reading now. This
That is the
these are,
additional.
if Lordship is pleased to come to page, the heading starts with the additional documents. Page 146. So regarding the additional documents, I am making all these submissions. Lordship will see down below analysis of the additional materials and findings thereon with regard to the point of charge.
So this is from the additional CS.
Additional CS,
And
where
this-
no hearing took place.
these were submitted on 29th of June.
Yes, Lordship. The previous day. So 178.8 says CRPC. 173. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form of prescribed. And the provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to the report forwarded under subsection 2. So this will consume with the original one. It is also. So it is permissible. So the learned trial judge has made a blatant error on law here. And after 10 years, after 12 years, these are offenses of very serious nature, Lordship. Now this PW A and B, they came forward in 2020. They were part of that activities of 2009 and prior thereto. They were the participants of a particular training program. We cannot find them immediately. And what they are saying before the magistrate in Delhi, that hold the trial outside Assam. Otherwise, our life will be threatened. It is recorded, Lordship. So in paragraph 190, it is very clear, sir, submitted on 29/6/2022, 2021,
Just come to para 177 once.
Lordship. Yes. Upon perusing the statement of protected witness C, I find that apart from two statements pertaining to Maoists, which I shall take up later, the rest of the statements level various allegations of serious nature, which is accepted as proof would almost constitute an organized crime of extortion, cattle smuggling, blackmailing people with honey trapping, criminal intimidation, etc. The subject area of these activities would be outside the jurisdiction of this court, which is only guided by the schedule of NIA, which is reproduced here in below. Here, apart from now a particular offense, there are 3-4 offenses. Like one, let us take an example. Today I was handling that. A case is registered under section 5 sections from IPC, 2 sections from PC Act. Which court will try? Here also some provisions are IPC, some provisions are NIA. That is why it is under the special NIA court. If suppose tomorrow the charges under the provisions of UAPA are not sustained at the level of charge framing, then the IPC sections will still remain. Then the learned trial court will have to send it to the sessions court. That provision is also there.
Which is it?
No. Which charge them? 228.
Of CRPC.
Yes. Framing of charge.
Yes.
Framing of charge. If after such consideration and hearing, here also the word hearing is inserted. As aforesaid, the judge is of the opinion that there is good ground for presuming that the accused has committed an offense, which is not exclusively triable by the Court of Sessions. He may frame a charge against the accused and by order transfer the case for trial to the Chief Judicial Magistrate or the other magistrate of the first class and direct the accused to appear before the Chief Judicial Magistrate, or as the case may be, the Judicial Magistrate of first class on such date as he deems fit. Thereupon, upon such magistrate shall try the offense in accordance with the procedure for trial of warrant cases instituted on a police report. So very clearly says, suppose this trial judge of the NIA court feels that there is not sufficient materials to charge the accused persons under section 18 and 39. The other sections will still survive. Now here in this paragraph 177, what Lordship has just indicated, he says, I shall take up later the rest of paragraphs, first 3 lines. I find apart from the 2 statements pertaining to Maoists, that means UAPA will come here. 2 statements, the rest will be IPC. So if the additional provisions are there, like criminal extortion, etc., he can add the provisions. There is no bar. He can add the additional provisions also. You know? And the NIA officer has the power to investigate. That comes under section 8 of the NIA Act. Section 8 says, power to investigate connected offenses. While investigating any scheduled offense, the agency may also investigate any other offense which the accused is alleged to have committed if the offense is connected with the scheduled offense. The legislator is well competent to see all this, visualize all these situations. So paragraph 178 in my humble submission is not legally tenable. However, with regard to these allegations, if the police of the state or any appropriate investigating agency having jurisdiction find them to be verifiable facts meriting an investigation, they can always pursue the due process of law. This is not warranted, Lordship, because the NIA officer is well competent and he has done it. Paragraph 185, the learned trial judge has said about the case diary. Finally, at paragraph 186 says, these materials, photo and photo identification memo are grossly inadequate to frame any charge against Akhil Gogoi, including any charge under section 39 UAPA, which as already discussed requires specific ingredient, prima facie and strict interpretation even for framing charge thereunder. So if suppose 39 is not there, 18 and 18 will be there, the IPCs will be there. (190). I have already placed 190. The delay part. The delay part is not a factor which can discharge a person. The case is of 2020. The case was registered, I think, on 13th or 14th of December 2020. Sorry, 19. Now coming to paragraph 191. Before concluding the discussion, this court is constrained to observe that in the interest of justice, the court has found the conduct and approach of the investigating authority, prosecution in this case, to be discouraging, to say the least. The court has high expectation from a premier investigating agency like the NIA, entrusted with the profoundly important task of protecting our country and us, citizens, from the menace of terrorism. The court hopes and expects that such high standards will be upheld for sake of the country, and this one will be just an exception. I fear to say something more on this. My learned friend get agitated again.
Look, why it was found discouraging? Any indication in the judgment?
This is the opinion of the court. On what basis, I do not know. All investigation, we have a total, yesterday I attended a seminar. We have a very poor level of conviction. Does it mean that the investigation agency are not doing their job properly? What about the high rate of conviction in some of the very serious cases of the country? So this kind of opinions, Lordship, will discourage the investigating authorities. They risk their life. And where they are doing in the hostile areas. Sabwa was a hostile area at that point of time. Most of their investigations relates to JNK, his NIA. And this kind of opinion, I think it's a very mechanical and casual opinion. On what basis, I do not know. If you want to discharge somebody, discharge can be granted, charge can be framed. That's all part of the game. And we have found materials and credible materials, cogent materials, which cannot be brushed aside in a casual manner. I have placed everything. I do not want to repeat again all those statements and all the scientific analysis. The analysis of the data recovered from the tablet, recovered from the Google and the YouTube. These are all supported by the necessary certificates under the Evidence Act. These are all part of the record. I am not troubling you. These are all part of the record, and the record is before this honorable court. Section 65B, certificate under Evidence Act, all the certificates of each and every part of the investigation, so far as scientific analysis are concerned, are given there. So yesterday the issue was, what is a prima facie case?
So learned judge has said there is no prima facie material,
No prima facie.
but maybe that is a,
We respect his opinion, but we are testing his opinion. It is as simple as that. I am placing one meaning of prima facie case from the book Words and Phrases, which refer to the judgment of the Supreme Court, AIR 1960, Supreme Court 1352. The prima facie case, a prima facie case does not mean a case proved to the hilt, but a case which can be proved to the hilt, but a case which can be said to be established if the evidence which is laid in support of the same are believed. While determining whether a prima facie case has been made out, the relevant consideration is whether the evidence laid was possible to arrive at the conclusion in question, and or not, whether that was the only conclusion which could be arrived at on that evidence. Then I am also reading few lines from the judgment of the same judgment, na? Judgment. A prima facie case does not mean a case proved to the hilt, but a case which can be said to be established if the evidence which is laid in support of the same were believed. While determining whether a prima facie case has been made, on the relevant consideration is whether on the evidence laid it was possible to arrive at the conclusion in
but
question.
these are, what is the context of these judgments, prima facie? Is it a civil proceeding?
No, it is a civil procedure, but the meaning of prima facie. Prima facie does not have a different meaning in civil or criminal, or at different stages, bail or
No,
discharge.
Mr. Saikia, that may have to be qualified a little bit, because you see what has happened. And again, yesterday also, 2 days back, we were having some deliberations on this. If you are talking about, say, a civil suit, an injunction application.
Yes, Lordship.
There, the prima facie material is something else.
Lordship.
The pleadings supported by affidavit,
Lordship.
and even the court is empowered to take evidence.
Lordship.
So in that context, to say that there is evidence to record a prima facie satisfaction
Lordship.
means one thing. But in a matter where a charge is required to be
Yes.
framed,
In the charge,
there
is-
it is the prima facie materials,
to draw a presumption,
correct,
to draw a presumption. So it is on a much lighter footing,
much lighter footing.
much lighter footing. Because the framing of charge said, if after consideration and hearing as aforesaid, the judge is of the opinion that there is ground for presuming that the accused has committed an offense.
You are
So,
reading from.
I am reading from the section 228.
228.
228, I'm taking the word from there. That he has to draw a presumption. Now, whether drawing of the presumption, Lordship will take from the same records. It can be subjective. But at certain issues, when there is no doubt at all, that these materials can be tested in the trial. If the prosecution able to prove it beyond reasonable doubt during the trial, then it will be a case for conviction, other it will be a case for acquittal. So the materials which we have furnished, the scientific materials, the statement of the witnesses, plus the documents which we have furnished, the transcripts, all these materials, the photographs, whether that can made it believable that the accused persons were actually involved in the offense or not. Our materials are very cogent, very credible. Overwhelming evidences are there. Telephonic conversations supported by telephonic the scientific analysis and report that these are genuine voices. There is very limited scope of doubting those evidences. I have placed everything, Lordship. So my humble submission to sum up everything, the learned trial judge has not properly appreciated all the materials we have placed. Lot of discrepancies and lot of findings. He cannot delve deep into the evidence materials at this stage. He can overlook and see whether a case is made out or not. He cannot deep, he went much ahead and he delved into analyzing all the materials and given his opinion. We have to prove it. And if we can prove it, Lordship, there is no way out. But they have to rebut it during the trial. These are believable and cogent materials. It cannot be taken so lightly. When the materials are not subjective materials, these are objective materials. Why I'm saying objective materials? Because these are the telephonic recordings, the visuals. There is no tampering, no doctoring of the audio. These are the reports. There is no doctoring of the voice. The voice samples were taken from them. It was analyzed in a accredited laboratory. Chandigarh, no? It has come from Central Forensic Laboratory, Chandigarh.
All right.
So that appreciation is incorrect in my humble submission. Then violation of natural justice, procedural lapse, and leaving aside the very vital fact that there is existence of terrorist gang under the UAPA. That aspect was not considered at all. And most of the findings and opinions in my humble submission, I should not use a very harsh word, but indicates that these are perverse findings.
Perverse is permissible. That's a question of,
Yes, yes.
there is no motive in.
My friend is also agreeing.
No, perverse is,
Altogether.
perversity of a judgment is a question of law.
Yes, yes. So that perversity looms large here.
All right, we have taken note of.
Lord. This is my humble submission. So my humble submission, Lordship may be pleased to. I'm not saying that Lordship will frame the charge here. Lordship will definitely give some observations on the materials and remand it back to the same court for fresh hearing. This is my humble submission. And after my senior friend completes Lordship, we'd like to submit a written arguments on Monday. Whatever I have submitted in a very concise way, in the bullet points, we'll submit, if Lordship permits.
No, no,
I'll not
certainly.
take 1225 pages.
See, these are, absolutely fine. Both
If,
parties should.
otherwise, if lordship.
My lord.
No, no, when you give us, when you make your arguments, you give us material, it gives us better insight to the,
Exactly.
we have to feel comfortable before taking a view.
In fact, my lord, our High Court rule says nowadays that practice we have given up. When I entered the profession, my lord, invariably when a hearing takes place, we are supposed to give a list of date. Along with, my lord, the points which should be argued. That is the practice, invariable in each and every case.
So that is correct.
What High Court rule itself provides, but nowadays, my lord, maybe because the number of cases have gone up, these and that.
So these
The
are not
biggest problem
possible.
he will face, my lord.
No, my lord.
But it
No,
is,
that's no, my lord. That is what actually, my lord, that helps the honorable court also.
absolutely, this is what we have been telling.
In
the-
summarizing whatever is the
we
argument.
need to have an estimate of time,
Yes.
because you see, we have to deliver the judgments. There are works lined up. Half an hour here and there can take a judgment back by 20 days.
Yes, yes.
Therefore, assessment of time is very important. And
That's the most crucial factor,
after
my.
court hours, you know how much of work is there. So anyway, Mr. Chaudhary, how much time are you likely to take?
I don't think I'll exceed the first half, my lord.
No, second half, we cannot continue. with
No,
this.
no, no, I'll not. My lord, I'll not.
I will not say a single word.
I'll not.
I'm completing, and if lordship give me permission, I can leave also. I have to do another.
No, no, you leave.
Highly obliged, lordship.
Don't leave this state. You can leave this court.
Till 10th, no lordship, no chance. Highly obliged.
May it please your lordship. My lord, I'll not be giving my rejoinder reply. I'll try to say what our perspective is in the matter, and we'll try to say, my lord, why the entire, my lord, projection of the prosecution is flawed. It's not only misconceived, it is flawed.
Yes.
My lord, let us first take that point of adjournment first, then I'll come to the merit. Now, my lord, the learned judge has recorded in the order that in the month of June 21, 21, my lord, the prosecution made their argument on the charge. Sometimes in September, we replied. Then thereafter, my lord, the matter was before the honorable court below on, what was the date? Impugn order. In the June 2021, my lord. Now, on that day, an oral prayer was made on behalf of the prosecution that they were praying for some time because the learned advocate general would be addressing the court, because in the meantime on 29, an additional charge sheet was filed. Now, my lord, the trial judge is a human being like all of us. He having heard the matter almost a year back, he must have prepared his work, my lord. This is not the only case he is dealing with. He may be based on earlier arguments he have proceeded in the matter. Now then came, my lord, this additional charge sheet. Now, what is this additional charge sheet, in respect of which, my lord, much is said, much has been told, and my lord, though towards the end, my learned friend has diluted his stand, but when he started his argument yesterday, even today, he was trying to impute motive. That's not fair, my lord, because the judge is not before.
That we have.
No, my lord. No, my lord. Short of saying, my lord, that he did mischief, everything was said. This is not fair. This is not done, my lord. Because the judge has no opportunity to defend himself. Because judge only writes. That's why, my lord, there is no requirement of making a judge a party.
He's taken back.
Yes,
He's
taken back. Yes. Now, my lord, will kindly come to the additional charge sheet. End of the day, my lord, whenever an argument is advanced in this type of cases, what is the test? The test is the test of prejudice. Now, whether, my lord, the prosecution was prevented from pressing into service any point, which my learned friend has argued before lordships in that context. Please come to page 258.
Achha, Mr. Chaudhary, before you go on to the facts.
Yes. No, I'll not go to the facts. Only for this purpose I'm referring.
Correct. Please tell us one thing.
Yes.
And this is, according to us, a very crucial area. forget the facts of the case. An order of discharge
Hmm.
is challenged by the prosecution.
Yes.
What are the parameters on which the appellate court will examine the order?
My lord, in my humble submission, whenever an order of discharge is put to challenge, then what an appellate court will look into the provision which enables the exercise of that power, and whether the safeguard and mandate which is prescribed in that section or the provision which enables either framing of charge or discharge, whether that has been followed or not. That's the only test, my lord. Because 227 and 226 are inbuilt. And the what is the import of 227 and 228? And by now, my lord, there are plethora of judgments.
So on this, would you place
Yes,
any
I'll
judgment?
come up. Just, my lord, on the facts, page 258.
Yes.
Now, this is the additional charge sheet. Please come to my lord, or Lordship may take note, my lord, para 16 at page 258 of the additional charge sheet. Para 16, page 258 of the additional charge sheet. That means in the additional charge sheet, my lord, this is what has transpired. And I may tell your lordships, at para 181 and 182 of the impugned judgment, this aspect has been dealt with. If at all anybody would have had any grievance, it is we. The prosecution has already come up that this is the additional charge against them. Tomorrow, if a hearing is denied, there is no question of prosecution, my lord, being prejudiced. Because prosecution's perspective is already there in the additional charge sheet under 173A.
No, what he is saying,
No, I'm coming.
we were not heard.
No, I'm coming. Now, my lord, lordship will also apply whether non-giving of hearing has done any wrong to the NIA. That also lordship can test. Now, my learned friend has developed an argument, which is not there in the additional charge sheet, regarding the expression terrorist gang. He says, even if you are not involved in terrorist activity, but you are guilty of being a part of a terrorist gang. Am I clear, my lord?
Yes.
My lord, this is highly preposterous, my lord. My learned friend has not read Article 20, Sub-Article 1. Please read Article 20, Sub-Article 1.
Constitution.
Yes. This is a fundamental law, my lord.
Mr. Satyanarayan, you are taking note.
My lord, please take note of this provision of, my lord, terrorist gang came into being on 14/8/2019. Am I clear, my lord?
Yes.
Now come to Article 20, Sub-Article 1. No person shall be convicted of any offense except for violation of a law in force at the time of commission of the act charge as an offense, nor be subjected to penalty greater than that which might have been inflicted under the law in force at the time of commission of the offense. My lord, on the date when A1 was alleged to have committed an offense within the meaning of section 39, my lord, this offense was not there. So unless an offense exists on the day when the alleged offense is said to have been taken place, you cannot be charged against that offense. So this is a constitutional prohibition. So my lord, that argument that I am a part of terrorist gang, it is preposterous. And neither in the first charge sheet or in the additional charge sheet, my lord, this case has not been pleaded. There is no charge frame on the ground that I am guilty of being a part of a terrorist gang. Well, there are judgments also on this point, because it struck me just now, that's why I haven't brought the judgment. Because the moment my learned friend was referring to 2L, then my anxiety was, my lord, when this provision was inserted. It came to be inserted in August 2019. And the alleged occurrences of before 2009.
No, Mr. Chaudhary, just to clear air of confusion, if any. We are not saying that his argument should not be tested. It will
No,
be
this is
tested.
not my case either, my lord.
But what is Mr. Saikya has argued
Yes.
is that forget whether he was a part of a terrorist organization. Terrorist organization has to be notified, and the period which is referred to, at that time, this organization was not notified. Leave it aside. But even if he is not a part of terrorist organization,
Then he is guilty of
he
is guilty of
formed a
153A, 153B.
terrorist gang.
No, terrorist gang is an expression. This came to become an offense only in 2019. Am I not clear to your lordships, my lord? That's why I read Article 20, sub-article 1.
No, terrorist gang is not an offense.
No. To being a part of a terrorist gang,
Hmm.
my lord, whatever it is, nothing can be, brought in, correlated with the expression terrorist gang in this case, for the simple reason, the offense alleged to have been committed by me is of prior to 2009.
Mr. Chaudhary,
Huh.
please appreciate, this
Yes,
is the
yes.
academic issue where the court would like to have a clear view.
Hmm.
This order can be
My
circumscribed in
lord,
many
I have
ways.
followed your lordship's point. Let me clarify.
What I'm saying is,
Yes,
your argument is valid when it comes to terrorist organization.
yes.
If it has to be a terrorist organization within the meaning of Section 2M of the UAPA Act, then it has to be notified and included in the
No,
schedule.
no, my lord. That is there. That argument is there. Additionally, what I'm saying is, towards the end, my lord,
Hmm.
to buttress his point
Hmm.
that denial of adjournment has caused prejudice to the NIA because they could not plead before the court below
Hmm.
that the A1 is also a part of a terrorist gang. That's what is argued.
Followed. So the issue that.
Mala, let me explain, my lord. I follow.
Yes.
There are two aspects.
Hmm.
First, if you are to charge me as a terrorist organization or terrorist,
That is
then
another.
there is a requirement of notifying me as a banned organization.
Correct.
That is one requirement. Now, the other requirement is, if now my learned friend has developed that argument that they could not bring it to the notice of the court below, that A1 is also a part of a terrorist gang. And to be a part of the terrorist gang, you need not be involved in terrorist activities.
No, you have to involve in.
No, but that is his argument.
No.
I have noted very carefully, my lord.
Yes.
That is required. I'm coming to that, my lord. I follow.
That is a very crucial aspect.
Yes,
If
I'm
the
coming, my lord.
view
I'm
of
sorry.
the court is against the prosecution, then it will have a relevant bearing.
Very fair.
Terrorist gang means any association other than terrorist organization,
Exactly.
whether systematic or otherwise,
Ah.
which is concerned with or involved in terrorist act. So all that is required to be shown is that this is an association which is involved or is concerned with terrorist act.
Yes.
Now, what is the terrorist
Now,
act?
the moment terrorist act comes, my lord, they're out of the bag. Because terrorist act, then it has to be by a banned organization.
No.
And yes.
See,
No.
2K. Please read 2K.
Terrorist act means, has the meaning assigned to it, section 15, and expression terrorism and terrorists shall be construed accordingly. So, my lord, this has made the job more tougher for them.
Right.
So, what I'm trying to say is, my lord, I'll reply to each and every query of your lordships.
Mhm.
Now, let me put the things in perspective. To ban an organization, there is a requirement of notifying the organization as a banned organization in the schedule.
Correct.
Now, as far as Maoist is concerned, my lord, it was done in June 2009, 29th of June 2009. Now, the offense with which the NIA is trying to correlate my activities with is prior to that period.
Absolutely.
There, my learned friend's argument today was, forget about whether I'm banned or not. He is involved in, a part of a member of a terrorist gang. That's what he was arguing, my lord.
Mhm.
Now, terrorist gang is an expression which came to be inserted in the Act, UAPA Act, with effect from, my lord, 14th of August 2019. In terms of Article 20, sub-article 1, if I am to be charged of being a part of a terrorist gang, within the meaning of section 2L of the Act, in that case, this terrorist gang expression should have been in the statute book in, my lord, prior to June 2006.
Correct.
It is not there. Therefore, Article 20, sub-article 1 says that you cannot charge any person of an offense if it was not an offense on the date when it was committed.
Absolutely.
So as a part of the terrorist gang,
Mhm.
if I am to be charged, then, my lord, this terrorist gang expression should have been there in the statute book prior to, my lord, the date when I was alleged to have committed or be a part of that gang.
No, that, when was the incident? It was before August 2019.
Exactly, it is
This
of before
Chabua violence-
2009.
Chabua violence and all these
No,
things.
no, Sabwa violence, my lord, they are not alleging.
That's why, Mr. Chaudhary,
Acha,
I
regarding,
wanted to,
regarding,
I wanted to give you this input.
okay, now
Because
lordship
that
is
is
trying.
not connected with Maoist.
No, no.
Terrorist gang has nothing
No,
to
my
do with
lord, my
Maoist.
argument is qua UAPA. My argument is qua UAPA.
No, Mr. Chaudhary,
Yes,
please,
no, acha, now, my
please,
lord.
please appreciate one thing. I'm giving you this inputs
Hmm.
so that you can respond to it in an appropriate manner. Because when he started this argument, perhaps you were not here.
Hmm.
That's why it's important that you understand what
Yes,
exactly is
Yes,
the context.
yes. Okay, my
Because
lord.
we have to deal with this.
Now let us try to.
Please be here for a minute. Terrorist gang has nothing to do with Maoist.
Hmm.
That is his argument.
Yes.
His argument is that
Hmm.
if you are found to be a member of a terrorist gang, then you can be prosecuted under the UAPA. That is
Because
his
whether
argument.
you are notified as a
Yes,
banned organization
yes.
or not. Yes.
Now, what is a terrorist act? Section 2K defines. What is section 2K? It says whatever act
15.
15. And 15 says anything to do with economic blockade, arson, these, that, all are terrorist act.
But,
So that is his
but
context.
by what means? But by what means?
Let
That
us
is
read-
most important.
Let us-
Okay, let us go very logically.
Yes,
Now let us read L once again.
yes.
Terrorist gang means any association other than a terrorist organization.
Mhm.
To this extent, my lord, what is clear is a terrorist gang could be an organization which need not be necessarily banned.
Correct,
To that extent, we are clear.
absolutely.
Whether systematic or otherwise,
Mhm.
which is concerned with or involved in terrorist act. This is very important. my
Correct.
lord. Now we must try to find out what is the meaning of terrorist act. Now please come to K.
Yes,
Terrorist act has the meaning assigned to it in section 15, and the expression terrorism and terrorist shall be construed accordingly. That means, my lord, to understand what is terrorist act, now we'll have to go back to section 15. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security or sovereignty of India, or with an intent to strike terror or likely to strike terror in people or any section of the people in India or in any foreign country. Now this is important. A, by using bomb, dynamite, other explosive substances or inflammable substances or firearms or other lethal weapons or poisonous or noxious gases or other chemicals by any other substance of hazardous nature or by any other means of whatever nature to cause or likely to cause. So these are the consequences I to 6. So my lord, in order to constitute terrorist act with a view to, my lord, these are the unity, etc., 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 it has to be done by what? By means of bomb, dynamite, explosive, firearms, lethal weapon or poisonous noxious gases, etc., etc., or by any other means of whatever nature to cause or likely to cause. Now, my lord, the later expression in the A, that by any other means of whatever nature, that meaning we are now, my lord, it is well settled. We'll have to apply the principle of usagem generis, whereby, my lord, if it has to follow the specie has to follow the genus. Now, question is, now we are referring to, my lord, what was done in Sabwa. Let us not talk of my lord jungles of Jharkhand and all.
Yes, yes.
Let us confine to Sabua.
You can forget the jungles. of
Yes.
Jharkhand.
Now in Sabua, what we are doing? We are protesting against CAA. In what manner? We are trying to say, we are trying to enforce bans. We are trying to, block highway. In a sense, we are also trying to, stop economic activities. By what means? Is it by means of bomb, dynamite, explosive, firearm, lethal weapon? No, by democratic means. Maybe there was some amount of force was used. My lord, in Kedarnath's case, when my lord, section 124 and 150 was examined by the Supreme Court, my lord, there, of course, UAPA was not involved. There, my lord, Honorable Supreme Court has a given. That was in the context of Article 19(2), that is the reasonable restrictions. When it comes to exercise, whether by making this law in the form of section 124A or 150, etc., the freedom guaranteed under 19(1) was violated. Supreme Court has negated them. There, my lord, the law has been laid down in paragraph 26. AR 1952-62 Supreme Court, page 955. My lord, I'm very happy that my learned friend has boiled down his argument to this. Thereby, he's trying to say, I'm also guilty of, my lord, being a part of this organization other than a terrorist organization. To bring me within that fold, first you will have to show that the means with which I was trying to, cause the economic disunity of the country, it must be by means of bomb, dynamite, explosive, etc., etc. Where are the materials, my lord? Where are the materials in the charge sheet to substantiate this? So, my lord, what Supreme Court has said.
No, he's relying on the CD transcripts of telephone calls. Mr. Bhattakur, have
Maybe.
you briefed him?
Yes.
Yes.
I
You
have.
briefed Mr.
Yes,
Chaudhary?
yes. Does it? Then, by making an appeal to the people, block the highway. I'm not using bomb, my lord. My lord will kindly see. When the consequences are serious, as a constitutional court, the duty of this court is also more serious, my lord. It's more important. It is not a normal offense. Here is an offense. If I'm charged with and I'm found guilty, my legal liberty will be curtailed for longer period of time. Unlike in the normal court. Therefore, my lord, lordship's concern should be more. The more the consequences, the more is the duty cast upon the court, my lord, to be very, very careful. Now, my lord, my humble submission is very simple. As far as terrorist act is concerned, is out of question. Now, my lord, just to give a glimpse of
Yes,
what
yes.
it is,
Yes.
your lordship has already dealt with issue while dealing with the bail application. I'm not saying, my lord, that is binding, but please have a look at that. Please have 2021 3 GLT 102. Oh, yes. Yes. My lord,
Yes, please.
there's one more thing I'm grateful to my friend, my lord.
Yes.
Now, please have section 20 of UAPA, my lord, for a moment.
Section 20.
Yes.
Yes, please.
Punishment for being a member of terrorist gang or organization. Any person who is a member of a terrorist gang or a terrorist organization which is involved in terrorist act shall be punished with imprisonment for a term which may extend to imprisonment for life or shall be liable to fine. My lord, either in the first charge sheet or in the supplementary charge sheet, I have not been charged with it, my lord. Section 20. I have been charged with under section 18 and 39. As a terrorist organization. Please come to the judgment, my lord.
Yes.
Now, my lord, exactly in the perimeter fact situation, please come to para 13, my lord. I think it starts with Mr. Chaudhary has argued.
Yes. Please.
Yes. Please come to the later portion, my lord. Contending that, has the lordship got it, my lord?
Yes, please.
Contending that while interpreting the expression or by any other means of whatever nature used in section 15(1)(a), the rule of usagedom generis would have to be applied, in which even a stone cannot be treated at par with the little means described in that section. In support of his arguments, Sri Chaudhary has placed heavy reliance on the observation made by the Supreme Court in so and so, so and so, by referring to other decisions, etc., etc. Then my lord will kindly come to para 24. Of course, it was in the context of Terrorist Act. Para 24. From a plain reading of the relevant provisions of the statute, it is evident that subsection 1(a) of section 15 of the Act of 67 would be attracted only if alleged act is in the nature of a terrorist act committed with the intention to threaten or likely to threaten the unity, integrity, security, and sovereignty of India, with intent to strike terror or likely to strike terror in people or in a section of the people by resorting to any one or more of the means included in the subsection of clause A of section 15(1), such as bombs, explosive substances, and other lethal weapons mentioned therein. However, in case of unlawful activity in relation to an individual or association, any action taken by such individual or organization, association, including spoken words, would also come within the purview of so and so. Now, my lord will kindly come to paragraph 28, my lord. Upon analyzing the ratio laid down in the aforesaid decision of the apex court, it becomes evident that an unlawful activity under section 2(1) of the Act could even be spoken words, including a provocative speech, but in order to constitute an offense under Act of 67, the same must be done with the intention to cause death or injuries to any person or persons, or to cause loss or damage to or destruction of any property aimed at disturbing the unity, integrity, security, and sovereignty of the country. Now, this is the dominant intention of wrongdoer must be to commit a terrorist act coming within section 15(1) of the Act. In other words, unless the act complained of strictly comes within the letter and spirit of section 210, read with section 15(1) of the Act, provisions of Act of 67 would not be applicable. What therefore follows is that unlawful act or any other nature, including acts of arson and violence aimed at creating civil disturbance and law and order problem, which may be punishable under ordinary law, would not amount to the come within the purview of 15(1) of the Act of 57, unless it is committed with the requisite intention.
Yeah, that's the law. That's the law.
That's the law. Now, my
Law
lord,
has been-
now what was done in Sabua? Disturbance, arson, etc., etc. Even, my lord, the gentleman, that police officer who was, I think a stone was hurled at him, my lord. Therefore, I think he had 1 or 2 stitches on his lips, my lord. Other than that, nothing had happened. I don't think my learned friend's emphasis was on this. His emphasis was on, my lord, terrorist, initially a terrorist act. Towards the end, he has boiled down to terrorist gang. But even, my lord, to be a part of the terrorist gang, I must be guilty of a terrorist act. And that terrorist act is defined in 15. So, my lord, apart from the requisite, my lord, intention, mens rea, it must be done with the means as explained in the section itself. So, unless that is there, my lord, it will be very difficult to say that, my lord, I am guilty of either an offense under the IPC or an offense under the, my lord.
No, Mr. Chaudhary, you are absolutely clear on that.
Yes.
And
My lord,
we agree with
because,
that.
my lord, I'll not, my lord, trouble your lordships again and again with the facts. My learned friend has read it several times. Now let us come to the basic point, my lord.
Please tell us one thing,
Yes.
whether the intent mens rea is there or not. Can that issue be gone into at this stage of framing charge? What is the legal proposition on that?
My lord, I will put it in this way, my lord.
And is there any observation in the impugn order that it was not done with the intent of such and such?
Yes, I'll come to that. My lord, let me put it this way, my lord. Be it an exercise under 227 that court found that there are no sufficient ground. Or my lord 228, there are reasons to believe that there are sufficient ground. My lord, in both these exercises, in my humble submission, I haven't found any judgment of the Supreme Court saying what I'm going to submit. That at both these stages, my lord, the satisfaction is subjective. But that satisfaction must be derived from objective material. I haven't found any judgment specifically saying, using this expression, which I'm using today before lordships. The satisfaction is on both count is subjective.
It has to be. It has to be.
And my lord, the materials based on which the satisfaction is derived or formed, it must be objective. Now, what is objective material? That means the ingredients required to constitute the offense is present. If it is present, then a trial court cannot say I will not frame charge. Whether eventually that lead to conviction or not, that's a different aspect altogether. If the trial court finds that the necessary ingredients to constitute the offense is absent, then my lord, he is fully justified. And my lord, the most important part is in the 79 Supreme Court, a handle has been given to the court in these matters. The reason being, my lord, section 227 was not originally there in the CRPC. It was brought only in my lord 1973 amendment, where having regard to the harassment which a person faces on account of a trial, this provision was inserted. That is why, my lord, in Pepsi's case, Honorable Supreme Court had said, merely because a magistrate can discharge a person, why not a high court under 226 or under 480? Therefore, my lord, while exercising power under 227 or 228, even I'm coming down to that question which your lordship very initially posed to me, what would be the yardstick? Or what are the guidelines to exercise that power? My humble submission is, my lord, the only guideline which is discernible or which is deducible is the trial court's duty is to find out that the materials, why I'm using the expression material is, my lord, at that stage it is not evidence. It will take the shape of an evidence or it will attain the status of evidence when during trial, my lord, it is laid before the court below. Now, if the materials required to constitute the offense is present, there can be no two opinions. There, my lord, as I said, one more handle has been given to the trial court. The suspicion that he is likely to or he must have committed the crime, then, my lord, it has to be a grave suspicion, as distinguished from a mere suspicion. My lord, the use of the expression grave suspicion, I think that is an aspect which goes in favor of the liberty of the person's mind. This is consistent with Article 1 and 21 of the Constitution of India. Now, my lord, with all respect, with all humility at my command, I am submitting, which is that materials which has been placed by the NIA before lordships, that these materials constitute the offense, but the trial court has disregarded it. That transcription, this is not by means of any terrorist means. Even if I am a part of the terrorist gang, I must be involved guilty of a terrorist act. Where is that? My lord, one judgment, my lord, 3 sentences, so lucidly Supreme Court has put it. Please have it, my lord.
Yes.
1994 SCC 76.
Yeah. Which is the paragraph?
Para 5, my lord.
Yes.
Section 227, introduced for the first time in the new code, confers a special power on the judge to discharge an accused at the threshold if upon consideration of the record and documents he considers that there is not sufficient ground for proceeding against the accused. In other words, his consideration of record and document at that stage is for the limited purpose of ascertaining whether or not there exists sufficient ground for proceeding with the trial against the accused. If he comes to the conclusion that there is sufficient ground to proceed, he will frame charge under 228. If not, he will discharge the accused. It must be remembered that this section was introduced in court to avoid waste of public time over cases which did not disclose a prima facie case and to save accused from avoidable harassment and expenditure. Next question is, what is the scope and ambit of consideration by trial court at that stage? Can he marshal the evidence found? I think, my lord.
Yes,
My lord may come to para 6. The next question is, what is the scope and ambit of consideration by the trial court at that stage? Can he marshal the evidence found on the record of the case and in the documents placed before him, as he would do on the conclusion of the evidence adduced by the prosecution after the charge is framed? It is obvious that since he is at the stage of deciding whether or not there exists sufficient ground for framing the charge, his inquiry must necessarily be limited to deciding if the facts emerging from records and documents constitute the offense with which the accused is charged. At that stage, he may sift the evidence for that limited purpose, and he is not required to marshal the evidence with a view to separating the gain from the suffer. My lord, on the aspect whether the trial court has dealt with the aspect of requisite intention, I'll come to it while dealing with this point. In my humble submission, my lord, at this stage of framing of charge, this is the exercise with which he is required. And even for the purpose of shifting the evidence, he has got a very limited role. Therefore, I would respectfully submit, my lord, perhaps at the stage of framing of a charge, the question of requisite intention need not be gone in. That will come only when, my lord, the materials which constitute the offense is there. In other words, my lord, the means with which the activity is carried out, whether it comes within either, my lord, either the IPC offense or under the UPA, if it is there, then it is sufficient for the purpose of, framing charge. Whether the requisite intent is there or not, that will be gone into at the time of trial. At that stage, he may sift the evidence for that limited purpose, but is not required to marshal the evidence with a view to separate the grain from the sap. All that he is called upon to consider is whether there is sufficient ground to frame the charge, and for this limited purpose, he must weigh the materials on record as well as documents relied on by the prosecution. Then, my lord, may kindly skip that portion. Please come to the next page. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged by cross-examination or rebutted by defense evidence, if any cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. In Union of India versus Prafulla Kumar Samal, this court, after considering the scope of 22-227, observed that the words "no sufficient ground for proceeding against the accused" clearly show that judge is not merely a post office to frame the charge at the behest of the prosecution, but he has to exercise his judicial mind to the facts of the case in order to determine that the case for trial has been made out by the prosecution. In assessing this fact, it is not necessary for the court to enter into the pros and cons of the matter or into weighing and balancing the evidence and probabilities, but he may evaluate the materials to find out if the facts emerging therefrom, taken at their face value, establish the ingredients constituting the offense. So, my lord, in my humble submission, the thrust is whether the materials which are brought on the charge sheet, whether if they are taken in its face value, it will constitute the ingredients which is required to constitute the offense. Now, my lord, the Honorable Supreme Court referred to the, my lord, the guidelines laid down in Samal's case, that the judge, while considering the question of framing the charges under 227, has the undoubted power to sift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. Where the materials placed before the court disclose grave suspicion against the accused which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. The test to determine a prima facie case would naturally depend upon the facts of each case, and it is difficult to lay down a rule of universal application. By and large, however, if two views are equally possible and the judge is satisfied that the evidence adduced before him while giving rise to some suspicion, but not grave suspicion against the accused, he will be fully within his right to discard the accused. Perhaps, my lord, this test will fully apply in this case. That in exercising his jurisdiction under section 227 of the code, the judge, which under the present code is a senior and experienced judge, cannot act merely as a post office or a mouthpiece of the prosecution, but he has to consider the broad probabilities of the case, the total effect of the evidence, and the documents produced before the court. And perhaps the word of use of the expression evidence. Anyway,
That could be on a lighter.
yes. Any basic infirmities appearing in this case and so on. This, however, does not mean that judge should make a roving inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial. Now the subpara. From the above discussion, it seems well settled that all that section 227, 228 states, the court is required to evaluate the materials and documents on record with a view to finding out if the facts emerging therefrom, taken at their face value, disclose the existence of all the ingredients constituting the alleged offense. So, my lord, I think, my lord, it can be summarized in this way, that if the materials which are brought on record in the charge sheet constitutes the, constituent which is required to, form the offense, then, my lord, the judge's duty is over. Now, he will not go to the extent of whether it can be proved beyond any reasonable doubt. All these things are not an aspect which needs to be gone in. Then, my lord, I'll refer to the para 8. This is for the purpose, my lord, when it comes to statute where, my lord, drastic provisions are made, then the anxiety of the court should be more. If a lordship will kindly come to page 86, the subpara. To put it differently, the ratio of the decision is that the provisions of the act need not be resorted to if the nature of activities of the accused can be checked and controlled under any ordinary law of the land. It is only those cases where the law enforcing machinery finds the ordinary law to be inadequate or to sufficiently effectively for tackling the menace of terrorist and disruptive activities that resort should be had to the drastic provisions of the act. While invoking a criminal statute such as the act, the prosecution is duty bound to show from the record of the case and the documents collected in course of investigation that facts emerging therefrom prima facie constitute an offense within the letter of the law. When a statute provides special or enhanced punishment as compared to punishment prescribed for similar offense under ordinary penal law of the country, a higher responsibility and duty is cast on the judge to make sure that there exists prima facie evidence for supporting the charge leveled by the prosecution. Therefore, when a law visits a person with serious penal consequences, extra care must be taken to ensure those whom the legislature did not intend to be covered by the express language of the statute are not roped in by stretching the language of law. But that does not mean that judicial officer called upon to decide whether or not a case for framing of charge under the act is made out should adopt a negative attitude. He should frame the charge if the prosecution shows that the materials placed on record and documents relied upon do give rise to a strong suspicion of the accused having committed the crime alleged against him. Now, my lord, having regard to this passage, now let us test the argument of my learned friend when he referred to the concluding observation of the trial judge that, in other words, my lord, the trial judge has lamented that NIA has not done its duty properly. Why the trial judge has said so? He's an officer of the rank of a session judge who is not competent to make that observation. I think, my lord, for making one observation by one of the trial judges, I think he was held. I know, my lord. Now, my question is, my lord, this is a very draconian law. It's a very drastic provision. It visits citizens.
Which observation, which trial judge?
I think in Borpeta, no? I think, my lord, I just forgot now. One observation was made by a trial judge from Borpeta. In which case, isn't it? Oh, yes. In connection with these encounters, an observation was made which was held across the state. So, what I'm trying to say is, my lord, the observation of the trial judge in the concluding part of the judgment has to be viewed in the context of the, my lord, consequence which such a law visits. If you do not have the
What-
material,
What was the actual import of that observation? That's what we are
according
trying-
to me, the import of that observation was, my lord, it's a very draconian law. It has got serious consequences.
Mhm.
Therefore, don't use your power, in a manner which is not envisaged. But at end of the day, if a case is not even fit to be, my lord, a charge is not fit to be framed. Forget, my lord, kindly see, my lord. The judge consider it not even fit to frame a charge. No, my lord,
but,
that order is subject to judicial review. I'm not on that.
That part.
No,
Mr.
what I'm
Chaudhary-
saying is, my lord,
Hmm.
since your lordship has posed a question and the other side also trying to harp on it, my understanding of that passage is very simple. All that the court was perhaps wanted to convey was, you need to be more serious in your job because you are a premier prosecuting agency of the country. That too, you have a specialized knowledge. Kindly see, my lord.
We will not go very deep
No, no,
into
I'm
it,
just
but
saying, my
Mr.
lord.
Chaudhary, that's not correct.
No.
The reason is as follows.
Yes.
Since the topic has cropped up, you see, in NIA is only responsible for carrying out investigation.
Exactly.
NIA is not the prosecutor.
Yes.
Prosecution has another limb. They will decide whether the evidence is good enough to prosecute. It is for the state machinery to decide whether they want to initiate a proceeding and set the law machinery into motion. Whether the statute is draconian on law, draconian or that is not a matter for the
No, my lord.
decision.
What I'm trying to say is, now, why NIA was, brought into the scene? Because purportedly, the petitioner is involved in terrorist activities. Now, what this premier institution has done, let us see, my lord, the trial judge has dealt
Is
with it.
there anything in the statute which lays down on what cases NIA can step in and what cases it cannot? Anything, any guideline anywhere?
There is an offense, my lord. Scheduled offenses are there, not in case of all offenses.
Okay. So this matter was handed over to NIA by a government of India.
Because the particular sections of the IPC and the UAPA Act, these are all covered in the schedule. So NIA will assume jurisdiction the moment the offense is incorporated in the schedule. No, my lord, here in this case, the alleged, my lord, training imparted to these boys of belonging to Maoist organization, etc., these are of 2005 and 2000, between 2005 and 2000.
That argument is accepted, Mr.
No, my
Chaudhary.
lord, what I'm saying is,
What you are arguing is accepted.
Yes.
You need no labor on that.
yes.
Terrorist organization.
No, I'm not on that, my lord. I'm in the context of that observation. Because the court felt, if you are so serious about your job, how come you are recording this statement of 2005 in 2019 or 2020?
That's
No, my lord.
we don't agree with that. The special judge ought not to have made these observations while framing charge.
And I'm just trying to make up. Now, therefore, my lord, what has fallen for consideration before lordships in this case is whether the materials which form part of the charge sheet, both 1 and 2, whether it contains the ingredients which is required to the constitute offense.
Correct.
In my humble submission, my lord, it is not there. As far as UAPA is concerned, there is no question. My lord, as far as IPC offenses are concerned, maybe, my lord, there is some scope of rethinking, my lord, because please come to section.
But that is a very important part. We were just
Yes.
about to ask you on that. The learned judge itself appears to have agreed that there could be scope of.
Yes.
Then how could they be discharged?
No, my lord. There, my lord, my argument would be, if your lordship feels the trial court faulted in considering as to whether there are sufficient grounds or not to the extent of IPC offenses, that I leave it to your lordship, my lord. That there I'll not make my submission that even there it cannot be said something like that. Now, for example, my lord, if your lordship will kindly come to
No, but what will happen in that case? What is the recourse under the law?
the recourse under the law is, my lord, it will not go back to that special court. It will go to the jurisdictional court for the purpose of framing charge.
Which court is to pass?
No, my lord, ordinarily, if offenses included in the schedule and other offenses are there, then, my lord, the special court can deal with it. But if the scheduled offenses are not there, then, my lord, this is the ordinary court of the land, ordinary criminal court.
So that is what we are asking
after framing charge.
after framing. Yes, that's what we are asking. So the charge framing is to done by the special Mia court only.
Because my lord, because there are offences which includes both schedule offences as well as other offences.
Correct. So Mr. Chaudhary, we are trying to understand how
Yes.
the law operates.
Yes, yes.
So you agree
Ah.
that even assuming that charge could be framed under
Well,
the,
whether. it
even
could
then
have
the
been-
matter has to go
no,
back to
it
the.
could have been, whether if there are sufficient materials are there, whether there is a case of arson has been made out, whether any role of the A1 is there. Well, these are the queries perhaps on a
No.
deeper thinking.
That's very fair of you, Mr.
Yes,
Chaudhary. You
yes.
are very, very fairly
Yes.
taking. We are asking these questions to understand the nitty-gritties of how this statute
Yes,
operates. So let us take it that your fair submission before the court that, and it also reflects from the order of the
trial
court
court
below
also.
that there was some doubt and perhaps there is a tacit agreement
Hmm.
that there could be ingredients of offences under the IPC. So even if that position is accepted,
Yes,
the matter has to go back to that
it will
court.
go back to the same court. Only thing is, or even your lordships can frame charge and send it for trial. No, I'm just saying, even that is permissible because appellate court is coextensive. Unlike a 226 proceeding, my lord, which is a power of judicial review, appellate court is always coextensive with that of the trial court.
Is there any judgment, any decision anywhere where the appellate court has framed charge?
Yes,
Where
so-
the,
but that, my lord, readily, I think, my lord, it is, anyway, my lord.
Acha, anyway,
That,
we
that
are,
may be, that may be.
we are trying to examine
Yes, yes.
various legal issues here. So therefore, some searching queries have to be made.
Maybe, my lord, there could be, my lord, end of the day, merely because NIA persists
Mhm.
that these materials constitute this offense, that's not the end of the world.
That's
Even
correct.
the court finds that no, these materials could form basis for framing charge under some other penal offences. That is always open, my lord. Not for the offences as they would like to contend, but maybe for offences which is to be gone into and find out.
So therefore, even assuming that this court holds that the schedule offences are not attracted,
Hmm.
even then the matter has to go back to the same court for framing
Yes.
charge under the
Yes,
novel IPC.
yes, because as of date, my lord, in the charge sheet, it contains schedule offences. The fact that lordship, even if your lordship set aside that or interferes with the, charge sheet to the extent that it cannot include the schedule offences, but for the other offences, it has to be done by the same court.
And it has to go back to the same court.
Not same code. Not same code. If trials by the magistrate to CGM and by the session judge to
After
session.
framing charge.
After framing charge.
Before
We cannot
framing,
frame charge because these are not scheduled offenses. Nia code.
where is that? Where is that law? That he
See,
cannot-
see, once I can it.
220.
Hmm?
That provision is NI Act is mentioned section 20.
Oh, sorry. That's the disadvantage of not being a trial court lawyer, madam.
Yes, but you're doubling up very, very effectively. That's,
Whereafter taking cognizance of any offense, special court is of the opinion that offense is not trivial itself, notwithstanding the trial offense, transfer the, I think lordships can take care of, take note of section 20. Thank you, Mr. Try such offense, so court and court to which the case is transferred may proceed with the trial of the offense as if it had taken cognizance of the offense. I think, my lord, the mandate is clear.
so that has to be exercised, power under 20 has to be exercised by the special court, not the high court.
No, my lord, what I'm saying is. Now, my lord, supposing, my lord, in a given case, let us take the example. Today, my lord, supposing we would have been before your lordships against framing of charge, then we would have come under 21. Now, even now, lordship is exercising power under 21. I think in that case, section 20 would be coextensive.
No,
No,
there is-
what lordships can direct is perhaps direct the special judge to transfer the case to the appropriate court. If your lordship takes the view that this is a case where charge under UAPA or the schedule offenses is not there, but it may involve offenses, then it will refer the matter to the appropriate court.
All right. Yes.
I think that is the Messiah particular provision of it. Huh? I could have powerful document. Oh. My lord, to the same effect are 2-3 other judgments, my lord. 2000, I'm not reading it, I'm just giving the paragraphs, my lord. 2008, 10 SCC, page 394, para 16. On the scope, no, judgment like on the scope of my lord. Huh?
This is para.
Para 16, my lord. It is right that the words "not sufficient ground for proceeding against the accused" appearing in section postulates exercise of judicial mind on the part of the judge to the facts of the case in order to determine whether a case for trial has been made out by the prosecution. However, in assessing this fact, judge has the power to sift and weigh the material for limited purpose of finding out whether or not a prima facie case against the accused has been made out. The test to determine a prima facie case depends upon the facts of each case, and in this regard, it is neither feasible nor desirable to lay down a rule of universal application. By and large, if however two views are equally possible, and judge is satisfied that the evidence produced before him gives rise to suspicion only as distinguished from grave suspicion, he will be fully within his right to discharge the accused. At this stage, he is not to see as to whether the trial will end in conviction or not. The broad test to be applied is whether materials on record, if unrebutted, make a conviction reasonably possible. Then, my lord, now, if your lordship would kindly come to 2012 9 SCC 460, para 30. Para 30. We have already noticed that the legislature in his wisdom has used the expression "there is ground for presuming that the accused has committed an offense." This has an inbuilt element of presumption once the ingredient of an offense with reference to the allegation made are satisfied. It's very important. So as long as, my lord, the ingredients to constitute the offense are not there, then power under 228 is not available. Then, my lord, 2019 16 SCC 547. Para 23. At the stage of framing the charge in accordance with the principles which have been laid down by this court, what the court is expected to do is, it does not act as a mere post office. The court must indeed sift the materials before it. Materials to be sifted would be the materials which is produced and relied upon by the prosecution. Sifting is not to be meticulous in the sense that the court dons the mantle of a trial judge, hearing arguments after the entire evidence has been adduced, after a full-fledged trial. And question is not whether prosecution has made out a case for conviction of the accused. All that is required is court must be satisfied that with the materials available, a case is made out for the accused to stand trial. A strong suspicion suffices. However, a strong suspicion must be founded on some material. This is important, madam. the material must be such as can be translated into evidence at this stage of trial. This is the line I was looking for. The strong suspicion cannot be, sorry, a strong suspicion must be founded on some material. The material must be such as can be translated into evidence at this stage of trial. The strong suspicion cannot be pure subjective satisfaction based on moral notion of the judge that there is a case where it is possible that the accused has committed the offense. Strong suspicion must be suspicion which is premised on some material which commands itself to the court as sufficient to entertain the prima facie view that the accused has committed the offense. I think, my lord, that this judgment throws enough light on, my lord, what the test is, my lord, in this regard. This sentence is very important in my humble submission. The material must be such as can be translated into evidence at this stage of the trial. Now, if at this stage of trial, my lord, NIA cannot, the prosecution cannot establish that I did these activities with the aid of so-and-so activities, then, my lord, a framing of charge under UAPA doesn't make any sense. And more so in a criminal trial law, my lord, criminal jurisprudence where the standard of proof is beyond any reasonable doubt. I can appreciate in a civil proceeding.
That is another matter.
Yes.
We are not
So all that I'm saying is, my lord, the materials must be such, it must be capable of translating into an evidence at this stage of trial. In other words, my lord, I'm not saying that, my lord, the evidence should be of such a nature that it must entail a conviction. Whether it constitutes the offense, at least the materials which are before the court.
All right, so you've made your point.
Yes.
Whatever materials were there,
Yes.
these materials must indicate a strong suspicion, existence of a strong suspicion that ingredients of the offenses charged under the UAPA Act is there.
Not merely suspicion.
Yes, strong suspicion. Now, what we will, in all probability, consider by reading the judgment, another threadbare reading, apart from other things, is whether the ingredients which according to us appears to be relevant
Yes.
have been discussed by the learned trial judge, and an opinion has been recorded that for these reasons, these are not treated to be,
Yes.
sufficient
Yes.
to raise a strong
In fact, in my humble submission, my lord, subject to what your lordships may say, if your lordships refers to, my lord, I may just indicate the pages, my lord.
Yes.
Page 74 and 75, materials which are available against A1, that is the respondent.
Running page.
Yes, of the paper book, my lord, papil memo. Then, my lord, at page 91, the court below peruses the documents. Page 92 to 96, the learned court below refers to, my lord, the documents, transcriptions, translations, conversations between A1 and others which were recorded. Page 97, that is document 44, that is scrutiny report of data on the Samsung tab of A1. Then page 98, my lord, document 47, scrutiny report of video seized by Tulumoni Duara. Page 98 is document 52, page 99, document 54 and 56 and 59. Then, my lord, most importantly, the trial judge at page 123 to 32, my lord, 133 to 132, he analyzes the materials which are available against the respondent. Qua section 80. Then, my lord, 135 to 36, it's a finding on section 120 BIPC. Section 136 to 138, finding on section 153A and 151B. Here, my lord, I leave it to your lordships, my lord, to take an appropriate view, whether whether this was, I mean, a very exercise properly done or it requires some consideration, my lord.
Which one? Which one?
Page 136 to 131. Finding on section 153A and 151B. Because 124 to stay, so 124 doesn't arise now, my lord. Supreme Court has stayed it. Then, my lord, page 138 to 142, the learned trial court deals with, my lord, section 39 of UAPA. Here, my lord, the trial judge deals with the statement of, my lord, protected witness A and B. My lordship knows under section 30 of the Evidence Act, a version of an accomplice can be taken note of in a trial or in a criminal proceeding only if the co-accomplice is also tried together. The moment, my lord, he becomes protected witness, his versions cannot be taken note of. That is, my lord, there is a Supreme Court judgment that emanates from section 30 of the Evidence Act, my lord.
Section 30 will not come in because that is for co-accused.
But he is a co-conspirator. He was a co-conspirator.
But has he also been tried?
Oh. And but no, my lord, at this stage of framing of charge, that aspect can be gone into. There's a judgment. 1998, 7 SCC 337, para 7. I'll place that, my lord.
No, please, what is the formulation? Can you please repeat it, Mr.
Yes.
Chaudhary?
What I'm trying to say is, my lord, a version of an co-conspirator, co-accused, etc. can be taken note of even at the stage of investigation or inquiry or trial, my lord, only when both of them are tried. Because it can't be, because the person is not supposed to give evidence against himself.
No, that is section 10 of the Evidence Act.
30, my lord. Section 30. In fact, my lord, the principles laid down in section 30 of the Evidence Act has been extended to the exercise of framing charge also. I'm relying on a Supreme Court judgment, my lord. That is, my lord, 1998, 7 SCC 337, paragraph 7. কিমান আছিলে হে? There are 6 है बोलेंगे नहीं? Yes. Para 6 and 7, my lord. Thus said, we may turn our attention to the confession made by Dr. Bansal and Jayant Suryaram. Under section 30 of the Evidence Act, a confession of an accused is relevant and admissible against co-accused if both are jointly facing trial for the same offense. Since admittedly Dr. Bansal has been discharged from the case, would not be facing trial with a Kalani, his confession cannot be used against Kalani. The impugn order shows that the designated court was fully aware of the above legal position, but surprisingly enough, it still decided to rely upon confession on specious ground that prosecution was not in any way precluded from examining Dr. Bansal as a witness in the trial for establishing the fact disclosed in his confession. This again was a perverse approach of the designated court while dealing with the question of framing charge. At that stage, court is required to confine its attention to only those materials collected during investigation which can be legally translated into evidence and not upon further evidence that the prosecution may adduce in trial, which should commence only after the charges are framed and accused denies the charges. The designated court was therefore not at all justified in taking into consideration the confessional statement of Dr. Bansal for framing charge against Mr. Kalani. Very clear.
Section, it cannot be done here because the protected witness has not been jointly tried
Yes.
for the same offense.
Yes. Para 7 also, my lord.
If had he been tried,
Yes. And then yes.
then because
Then
of
he-
section 10, it will be relevant fact.
Yes. Yes.
And because of 30, it would have been acted upon.
Yes.
But this question does not arise here.
No, what I'm saying is, my lord, end of the day, they're relying heavily on the protected witness A and B for bringing in this UAPA Act, my lord. They're otherwise, my lord,
They have not been charged.
but for these two version, my lord, they got no material regarding UAPA. Absolutely none. Only arson or, my lord, asking people to join agitation. There's no other material throwing thrown. Other than that, there's no evidence. So far as confession of Jayantara is concerned, this same can undoubtedly brought on record under section 30 to use it against Kalani. But then the question is, what would be the evidentiary value against the letter? The question was succinctly answered by this court in so and so. The proper way to approach a case of this kind is first to marshal the evidence against the accused, excluding the confession altogether from the consideration and see whether, if it is believed a conviction could safely be based on it. If it is capable of belief independently of the confession, then of course it is not necessary to call a confession in it. But cases may arise where judge is not prepared to act on the other evidence as it stands, even though he believed it would be sufficient to sustain the conviction. In such an event, the judge may call in aid the confession and use it to lend assurance to the other evidence, and thus fortify himself in believing what would aid in the what without the aid of the confession he would not be prepared to accept. The view so expressed has been consistently followed by this court. Judged in the light of the above principle, the confession of Surya Rao cannot be called in to frame charge against Kalani in the absence of any other evidence to do so. So from both perspectives, my lord, it was said that evidence of the version of this this gentleman called Bansal could not have been relied upon. So, my lord, these are the factual premise, my lord, on which, my lord, they were trying to build a mountain out of the molehill. In my humble submission, my lord, it falls short, my lord, of the requirements envisaged by criminal jurisprudence. Therefore, there is no question of framing any charge under, my lord, the provisions of UAPA Act. And regarding whether, my lord, the acts of omission and commission, which has been attributed to the, appellant or maybe some of others, whether it constitutes some of the penal offenses like arson, destruction of property, etc., etc. These are matters, my lord, if there are enough materials on which they have not laid the proper emphasis, my lord. If on a reconsideration, my lord, it is possible, this otherwise, but prima facie, even for that also, my lord, I don't find any materials. Therefore, my lord, to sum up, my lord, I'm not troubling your lordships with the versions, my lord. In fact, if your lordship listens to the speech which the respondent has given, he has repeatedly told, don't resort to violence. Don't resort to violence. This is not the time. Idea was to, my lord, organize public support so that people speaks in unison that we do not want CAA. That was the only purpose. My lord, lordship knows when a mass movement takes place, it is not the only organization which was spearheading this, my lord, protest. This was spearheaded by several organizations, including All Assam Lawyers Association, my lord. In fact, my lord, I was one of the first few persons who gathered in, my lord, in the midst of that COVID in, my lord, Lotus Hill Playground, where first, meeting was organized. Does that mean, my lord, I'm guilty of terrorism? Or I'm guilty of, I've got every right under Article 19(1) to say what is good and what is bad for the state. Well, it's not my perception. I felt that what is being done is not correct. Therefore, we are democratically protesting. Yes, in that process, everybody is not so sane, my lord, like as the government would like people to behave. They don't behave sanely when it comes to plundering the state's money, my lord. Their sense comes only when, my lord, they're trying to find fault with others. Yes, some excesses have taken place. Let us be very candid about it. This is not my case. Like in some of the incidents which happened in Guwahati. Then, my lord, that these were spearheaded by the organizations which the respondent represents. Then you, jail him, convict him. I know even I am against, my lord, destruction of public property. End of the day, it is taxpayers' money, my lord. Therefore, my lord, that is an aspect, perhaps lordship may give a due consideration to that. But otherwise, my lord, legally speaking, I don't find, my lord, any material irregularity having been committed by the trial judge. in refusing to frame charge in the circumstances of the case. That is my humble submission. But again,
Yes,
my lord, I'm not reading the speech and all my learned friend has already read.
is already read.
So my lord, I'll be only multiplying the effort. Therefore, I have refrained from doing that. In principle, my lord, my simple case is the required ingredients to constitute the offense is not present. And therefore, the trial judge was within its right, my lord, to decline to frame charge. And deeply obliged.
So far as other three accused are concerned, your lordship, basically, so far as other three accused are concerned, your lordship, that if your lordship go to the charge sheet and other documents, it is basically the investigation agency's case is against the accused number one. Although 2, 3, and 4 are roped in, your lordship, but there are no material, your lordship, so far as the evidences produced by the, so far as the materials produced by the investigation agency is concerned. These three accused are concerned, your lordship, there is no material at all. No overt act has been attributed to these three accused, your lordship. If your lordship, see your lordship, I have just, your lordship, I will not take much time since the most of the arguments has already been advanced. So far as accused number 3 is concerned, your lordship, PW 5 has just mentioned his name. No overt act has been attributed. PW 7 said that he had seen him accompanying the A1. He also has not attributed any overt act against the accused number 3. PW 9 said he knows him personally and had telephonic talk, but what the telephonic talk was about, that has not been disclosed. PW 6 says he knows Manas and talked to him regarding protest and paper party work, and PW 11 said he personally knows the accused number 3 as the working president of Chhatra Mukti Sangram Samiti, not KMSS, that is students wing, had phone talk with him, and why he had talked with him, that has also not been disclosed. And PW 15 said he knows Manas. These are the, so far as neither in the photograph nor in the telephonic conversation, the accused number 3's name has cropped up anyway, your lordship. And secondly, your lordship, so far as the accused number 4 is concerned, PW 5 had stated that he knew B2, the accused number 4. PW 9 had stated about his, he knew him, but no overt act is attributed to him. PW 10 and 11 has stated that they knew B2 and had talked with him and in connection with the process. These are the, your lordship, statements as regards these two accused is concerned. So far as the third accused number 2, Dhurjo Kaur is concerned, your lordship, similar statements are made, your lordship, but no overt act is attributed, except there is a one telephonic conversations relied on by the investigating agency between accused number 1 and accused number 2. In my humble submission, if your lordships go through that telephonic conversation, your lordship will find nothing incriminating they have talked about. It is only about the protest and the manner of protest, your lordship, that has not been disclosed by any one of them. They have said that you prepare for protest against this car. These are the materials against this. And so far as PW protected witness A, B, and C is concerned, they have not made any mention about these three persons, your lordship, these three accused persons. So if your lordship sees section 39, your lordship, section 39 is relatable to, your lordship, the statements of PW protected witness A and protected witness B. So far as this protected witness A and B is concerned, this is, your lordship, relates back to the year 2009 when we are not even born in the KMSS, your lordship. We have not even joined. It is not their case also, your lordship, in the charge sheet that these three petitioners, your lordship, these three accused persons has any link with the banned organizations or terrorist organizations or anything else, your lordship. Your lordship will kindly note one aspect, your lordship, from the charge sheet, your lordship. Page 184, Your Lordship. I just reading it, Your Lordship.
Yes,
First line, Your Lordship, investigation on the role of Dhurjo Kumar. Accused number 2.
yes.
A2 is closely associated with A1 and supported the ideological inclination of A1. The accused has an ideology of the same spectrum as ideology of CPI Maoist. This is their, Your Lordship, statement in the charge sheet, Your Lordship. So far as 3 and 4 is concerned, Your Lordship, similar line is, Your Lordship, that closely associated with A1, supported the ideological inclination of A1. The accused has an extremist Maoist ideology. And 4 is closely associated with A1 and supported the ideological inclination of A1. The accused has an ideology of the spectrum of ideology of CPI Maoist. There nowhere stated that, Your Lordship, and there is no documents, no materials, Your Lordship, to find out, Your Lordship, what ideology, Your Lordship, we believe in, Your Lordship. It is only a vague statement, Your Lordship, without any material, Your Lordship, just to rope us in under section 38 and section 18 of UAP, Your Lordship. This has been done, Your Lordship. If Your Lordship go through the entire material, Your Lordship, from statements of the PW1 to PW19, which has been read out.
So are you saying, assuming,
No.
we're not holding it
Lord,
for now, assuming that no charge under the special act
Lord,
is framed, are you saying that your clients could not even be proceeded? There's nothing to even frame charge under the IPC offenses?
no, that I will not say, Your Lordship. Our basic concern is, Your Lordship, this section, Your Lordship. At one point, Your Lordship, it is what has fallen from Your Lordship's mouth. The learned trial judge has held that there may be offenses under IPC sections. There is a one finding by the, that is also there, Your Lordship. So far as those parts are concerned, that probably, Your Lordship.
That part has not been challenged by the respondents. They have not challenged that finding of the trial.
No, we have not challenged that, Your Lordship. We have not challenged it, but we are basically, Your Lordship, since we have been discharged already from this, the question of challenge did not arise, Your Lordship. And they put this to challenge, Your Lordship. And our main concern is, Your Lordship, is that even by any standard, Your Lordship will find, if Your Lordship go through and definitely go through the evidences, Your Lordship, that there is nothing in their charge sheet, Your Lordship. And so far as this terrorist gang is concerned, Your Lordship, if Your Lordship go through the charge sheet, there will have to be some material, some statement that their case is that we are part of a terrorist organization, not terrorist gang, Your Lordship. The word is not there in
No, Mr. I've said it when their argument is that there are evidence to show that the accused number 1 had led a movement to make economic blockade, disrupt the economic activities of the state. And in trying to do so, there was acts of violence where somebody has sustained injury, a railway station has been torched, and some government vehicles have been torched. And there were attempts to Gherao, including the former chief minister. So this was a concerted move on the part of the agitationist to completely bring the economic activities of the state to a standstill, challenge the sovereignty or the authority of the state, and also to cause wide-scale damage, destruction to public property. So the learned senior counsel for the appellant has argued that the telephonic conversation and other materials go to show that the entire exercise was spearheaded by the A1 and the A2, A3 and A4 and some other persons who are not accused. They had played an active role. So he submits that by these activities, they have committed terrorist act, which comes within the purview of section 15. And they are also a part of terrorist gang. This aspect of the matter has not been considered by the trial court. And that is because we were not given an opportunity to argue the matter after the additional charge sheet is filed. That's this long and short of their case.
Lords,
That's all.
Lords, No, your lordship, that has already been dealt with by the learned senior counsel appearing for the accused number one, your lordship. So
Hmm.
far as I am concerned, your lordship, I was present at the relevant point of time before the trial court and I have argued my case, your lordship. So far as that factual part is concerned, your lordship, what has been submitted by the learned senior counsel on instruction, your lordship, that
We don't know, so that is why we are again and again asking.
No, your
If we
lordship.
find that these aspects have been considered and an answer has been given, then we can tell them, "Please
lordship,
say what is wrong." But if no answer has been given, the matter is going back.
lordship. One
Be
thing
very
is
sure
sure,
about
your lordship, that your lordship will find it, your lordship, the learned court below your lordship has dealt with these issues. your
We'll see, we'll examine.
lordship, that those issues have been dealt with at the later part, your lordship, so far as the additional charge sheet is concerned. Why it is not.
Because
your
at this stage, the court is not concerned about whether there are materials to frame charge or not.
Lordship,
The court is only concerned about the procedure followed,
lordship,
because that is the only way we can maintain fairness to both sides.
lordship.
There cannot be,
That your lordship will definitely go through, but.
we
your
are not
lordship-
giving any opinion whether charge can be framed, should not be framed. That's not going to be the,
I leave it to your lordship.
if we find that the opinion is recorded by the trial court based on relevant consideration, and that is a possible view, that is the end of the
That
matter.
is, that is,
insofar as
that is what your
prosecution is
lordship will do, definitely, your
concerned.
lordship.
If we
But
find
so-
that these aspects of the matter have not been considered
Lordship,
and a view has not been recorded, then obviously this has to be rectified.
in my humble submission, your lordship, what I have seen from the judgment, these issues have been dealt with. Their additional searches has been, your lordship, accepted on date, your lordship, when they filed it, your lordship. Their prayer for your lordship, keep secrecy was allowed on 28 when the application was made, your lordship. And your lordship, on 21st, your lordship, when the matter was taken up, it was told to the councils for the learned councils for the NIA that it will be the last chance when on the next date you come on 29th. On that day itself, on 21st, they prayed that learned advocate general is appearing, therefore we need time. Otherwise, on that day itself, your lordship, the matter would have been, your lordship, completed, hearing would have been completed. For their special prayer, this was allowed. And even otherwise also, your lordship, there is no prayer for adjournment, your lordship, so far as in writing. There is a verbal prayer for adjournment.
But
your
then
lordship.
that was rejected.
That was rejected.
Then
your
if there was no prayer, where was the question
No,
of
no, that
rejecting?
is what, your lordship, I am saying, your lordship. No, the other things, your lordship, the 200 page, 1200 page of written argument, it is absolutely, your lordship will kindly see, this is not part of the appeal. So we could not counter. Whatever it is there, we have said. We have said that there is a prayer, and when we said we have objection, but we said we leave it to the discretion of the honorable court to grant or not to grant time. And so far as other things are concerned, your lordship, there is no pleading at all, your lordship, that these orders are backdated, that, your lordship. Unless it is there.
That's correct. We will consider,
Lordship.
you have made your submissions,
Lordship.
but without commenting on the propriety, correctness or anything, which we will go through.
Lordship.
We'll go through the entire record and see. But one thing must be borne in mind, whether it is this side, that side, whichever side. The court orders are respected, not because they are always 100% correct,
Lordship.
but because the process through which the orders come out are transparent, fair.
Lordship.
Therefore, whether it's the bar or the litigant, they accept the court orders subject to right of appeal, primarily because it is the outcome of a very fair, transparent process. We hear matters in open court, submissions are made, these are dealt with in it. So if the fairness in the court process is anyway impinged,
That
that
your lordship
is
will
a very
definitely look
serious.
into, your
So we'll
lordship.
look
What-
into that.
Yes,
We'll look
what
into
we can only do, your lordship, we can submit, your
you
lordship.
can submit.
And what has happened before me, I am submitting it, your lordship.
We'll submit,
Lordship.
we'll
That is-
consider
that is
this.
there. And so far as these statements of the phone calls, your lordship, is concerned, I just want to point out one thing, your lordship. If your lordship go through the telephonic conversation, your lordship will find that whatever incriminating, your lordship, is shown in these phone calls has not fallen from the accused mouth, your lordship. It has fallen from the mouth of the other persons, your lordship, who is in the other side of the conversation, your lordship. And your lordship, these people, if it is at all a conspiracy, these people has not been roped in, your lordship, as a co-conspirator, not been accused, none of them, your lordship. Your lordship will kindly note that, your lordship, whether it is that first statement of the learned Borbora, your lordship, or your lordship, that by Miss Borthakur, your lordship, Nia Vaideo, your lordship. These are statements followed from their mouth, your lordship, and that has nothing to do with me, your lordship. But they have not been roped in as an accused, your lordship. That aspect, your lordship will kindly note, and your lordship will kindly note that the translation part, your lordship, in one statement, your lordship, after that long statement by the other side, your lordship, that in Assamese it is hobo. Thik ase hobo. Now that has been translated as all right, it is done. As if I promise to do as you advised. Then hobo means, your lordship, that yes, moi shunilu. But they have very carefully.
Hobo means all right.
Yes. Hobo, all right. They said all right, done. That as if I have promised to do the things he has suggested to me. That your lordship will kindly note, your lordship. And your lordship, the word used by Mia Baidu is, your lordship, is Kelimil in Assamese. But they have translated it as a chaos. But chaos has some meaning, your lordship, not like it is in Assamese. Chaos means, your lordship, disrinkhola. So these kind of, your lordship, translation.
And what is the English word for kelimeli?
Kelimel, your lordship. In fact, your lordship, that I have searched, your lordship, I could not found, your lordship. But it is not chaos, your lordship. We normally, your lordship, we use in our normal parlance, your lordship, whenever we converse with our people, your lordship. The ঘরখন খেলিমেলি হয়ে আছে, this kind of things, your lordship. The chaos is something more. It is deliberately, this has been translated into, your lordship, these words are translated so that some meaning can be given to it, your lordship. That your lordship will kindly note, your lordship. And so far as this another aspect, your lordship, the photographs, your lordship. All these photographs, if you, your lordship, see, your lordship will find none of us is present there, your lordship. And there are, your lordship, photographs of different organizations, people from all Assam Chutia Jati Chhatra Sangha, all Assam Students Union. But there is nothing, your lordship, wherefrom they can show that any of us was present in those, your lordship, hands. But they have annexed it. And it also reflects that this is a spontaneous movement participated by all organizations, your lordship. That aspect, your lordship, will kindly note. And your lordship will kindly note the statement of PW5, your lordship. PW5 statement is important, your lordship. They have not read the entire statement. In that statement, it will be reflected that they have this movement at Jorhat was organized, spontaneously organized, and it participated by all organizations, including the former chief minister and other leaders of the political parties and other organizations, your lordship. That part, your lordship, they have not shown to your lordship, probably, your lordship, since it is not required for them to show. But your lordship, that will show that it is a spontaneous movement where different organizations participated, your lordship. And one more aspect, your lordship, will kindly note, your lordship. They said that this is a conspiracy. We have not been charged under, your lordship, section 16 of Commission of a Terrorist Act, your lordship. We have charged under conspiracy under section 18. But to show that terrorist act has taken place, they have shown some photographs, etc. And that terrorist act is result and outcome of, your lordship, conspiracy hatched by these people, your lordship. Now, your lordship, will kindly note one aspect, your lordship. If at all terrorist act took place, who are the persons who, your lordship, who participated in terrorist act? No one has been charged. There are photographs they have annexed, your lordship. Those persons were not brought in as the accused, your lordship. Now, conspiracy took place. We conspired, your lordship, and they say by photographs, etc., the terrorist act has been done pursuant to that conspiracy, your lordship. Now, someone will have, your lordship, executed that conspiracy. Who are those people? And we are not charged under section 16, your lordship, at any point of time. Therefore, your lordship, conspirators they have brought in, but the actual perpetrators, your lordship, they did not brought in.
All right,
Lordship.
all right. So that's all.
That's all, your lordship. Your lordship, I also want to submit a
Written note.
submission.
Yes,
There are some judgments I am relying on, your
all
lordship.
right. Yes. All right. Uh,
Appellant arguments already
Sorry?
considered by
can you come a little
my
closer? here?
lordship. Senior counsel, appellant argument already concluded, my lordship.
So we'll close the matter.
Close the
Nothing
matter.
to reply.
Permit us to file gist of written argument. my
But
lordship.
there were some questions we would like to put to the council.
Otherwise.
Yes.
Mr. Saika wanted the matter to be listed on Monday.
No, my lordship. Only if we submit written argument.
All right, then we'll post it on Monday. You submit written argument.
Hmm.
But you must brief him. He is not aware of the arguments made.
Now come.
And you are saying that nothing is to be said. They have come up with some formidable argument which has to be addressed. Mr. Fukon, are you also there? No, there are some legal issues. We would like to have some. So we post it on Monday. If he wants to argue, otherwise we'll close it.
Lordship.
All right, take down heard Mr. D. Saikal and senior counsel assisted by Mr. L. Satyanarayan and counsel appearing for the appellants in both these cases. Also heard Mr. K. N. Chaudhary, learned senior counsel, and Mr. S. Bhattakur, learned counsel appearing for the respondents. Full stop. The arguments from the learned counsel for the appellants as well as the respondents counsel have been heard. Full stop. However, due to paucity of time, this matter, further hearing of this matter would not be possible today. So as such, on the request of learned counsel for the appellant, register to list these appeals again on Monday, give Monday's date, so and so as fixed parted matter. If there is nothing to argue, then you conclude it with a written argument. But you must tell him what are the points argued. You must tell him because otherwise he will not get a chance to. All right, the other bench will sit at 2.
Well,
You are
That
there.
medical matter, my
How
lord.
much time will it take?
15 minutes. It's a covered case.
All right, and there is another matter. Mr. Mahmood is there perhaps.
In any case, today I think there's a reference also.
There's a reference. So if it requires a lengthy hearing, then
My lord, actually the issue is covered. That's why I'm saying, my lord, it will not be.
that's your submission. If they don't agree, then we are left with no
No,
option.
my-
but
in fact, they're working on some amendment of the yesterday Advocate General called me up. But the fact that, my lord, the classes have started and by their own account, 3 vacancies are there. Though we are 5, I said for the present, give us provisional admission. And subject to what this is.
Are they agreeable to that?
More or less, but they would like an order. They do not.
May I please the lordship?
Yes,
My lord, the other day, my senior has already argued for most part, my lord, regarding the authenticity of the birth certificate that had relied upon, my lord, as well as about the HSLC certificate that we are relying on. Now, my lord, I would like to place certain documents before your lordship, my lord, will be very important.
don't accept documents like this.
No, my lord, here is an application, my lord, that needs to be filled up when a person applies for a delayed birth certificate, my lord. And my lord, in point number 7, my lord, it is mentioned that documents that needs to be submitted when applying for a delayed birth certificate, my lord. Number 1, registered hospital government private certificate regarding the age or birth or age proof. The second is the school certificate or the admit card. Now, my lord, as far as the school certificate or admit card is concerned, the HSLC certificate is there, my lord. So, my lord, now the question arises, which document did they relied upon while submitting the application for a delayed birth certificate? We have the HSLC certificate, which shows that she is of the age of majority. And now, my lord, God knows what document did they submit for the birth certificate, my lord. The Honorable Chief Justice already called for the records. No records were found, my lord, regarding what document they submitted for the delayed birth certificate.
Mr. Your name, please?
My lord, S.H. Mahmood.
Huh?
S.H. Mahmood.
S.H. Mahmood.
Yes, ma'am.
Where is the senior Mahmood? He
My lord,
left?
the senior Mahmood is in court number 17.
Acha. So you see, there is a problem here. We have gone through the record. The school living certificate shows the date of birth is 2004.
Yes, sir.
But the birth certificate and the Aadhaar card shows it is 2005.
My lord, 2000
Listen to it, because we are going to pass an order. If you want to listen, you listen. Otherwise, you take your seat. When the court is communicating, listen to it. Therefore, there are two sets of public document issued by public authorities which reflect to different date of birth. If this is accepted, then she is a major. If that is accepted, she is a minor as on date. Both these sets of documents are without any contemporaneous record. Both these entries were made apparently on oral representations made. Therefore, there is no scope for this court to choose one document over the other. There is no such principle. We have not seen any decision which lays down any guiding principle on that. Till the time the court is clear on which of the two documents can be accepted as the genuine birth certificate and what is the reason, merely you saying will not do. You say that is correct, they say this is correct. You will have to show us something more than that to accept your document. Otherwise, we'll accept their document. That is the law. That is the principle of law.
Yes.
That is how section 101 and 102 of the Evidence Act operates. You put one document, they put one document, your case cannot be accepted. Your materials has to be more, overwhelmingly more than their material. Otherwise, we cannot.
Yes, ma'am.
Are you ready to argue on that today itself?
I'd like to place one judgment of the Honorable Supreme Court, my lord.
On what point?
Regarding a birth certificate that is issued after a long period of time, after the birth of the person.
What about Aadhaar card?
My lord, petitioner does not have that.
That's why we are saying, come prepared. And in any case, Mr. Chaudhary, even if we hold that she is a minor, she is not going back to you. She will stay in the state home and until after she attains majority, then she will be at her. So she is not going back to you. These are matters which will require a little more application of mind. This is we find it's a very peculiar habeas corpus where the person himself comes to the courts and says, produce me before the court. So these are technical defects which we will not go into. Otherwise, on technical ground, the writ petition can be dismissed. But we don't want to be so technical. The petitioner himself comes to the court and says that
And madam, he has filed this case through her uncle.
whatever. So then, but anyway, these are technicalities. But the point is, from the materials available on record, we are unable to take a decision as to which of the date of birth is correct. Both are equally right or equally wrong.
Yes.
If you want to finally argue today, we'll hear you, but no adjournment. Then in that case, either we'll accept it or we'll dismiss your writ petition. But if you want this matter to be further examined, we can have it immediately after the Bihu holidays. Come prepared on that. But the fact is, if we accept your argument, she goes free. If we do not, then she stays in the women's home. And you have to tell us what is the difficulty with that.
My lord, if I may kindly start my argument, and in the meantime, my senior may come.
Today, we don't have much time. So you have to finish it off in 15 minutes.
15 minutes, my lord.
No, because there is a reference and there is another matter. 15, half an hour, and the government advocate another 10 minutes, that's all. What is the tearing hurry?
Because she's been in this.
She's been in the home since last 3 months.
Yes, ma'am.
Why can't you wait till 18th or 19th?
Okay, my lord.
What happens if she continues in that home till she attains 18? She's 17 years now, 17 years plus.
There is no difficulty. For our side, from our side now, there is no difficulty. Well, the Lordship has passed the last order, pursuant to your Lordship order, well, the affidavit of the IO OC has been filed. OC, he is also personally present, well, but he offers unconditional apology well, for being late in attending the court on that day. Lordship kindly consider that affidavit, well, he is here, well.
So we would not like to hurry up in this kind of matters. We would like to go a little and see the minute fine prints of what is happening. These are not usual cases that we come across. The petitioner doesn't want to go to her parents. She is relying on one document which shows she is a major. Their parents are relying on another document which shows she is a minor. Both are, as we said, both are documents issued by authorities. So the entire dispute is which of the two documents can be accepted. And the judgments which were relied upon on the other day by Mr. Mahmood have nothing to do with this case.
I have one important judgment.
Yes, give it. Then we'll close the matter today.
So for the court, what is this?
There are two judgments, one from the Allahabad High Court and the matter went to the Honorable Supreme Court. My lord, of the facts of the case were that, my lord, there's a famous politician in Uttar Pradesh who goes by the name of Azam Khan. Now, what happened was that Azam Khan wanted his son to contest the state assembly elections, my lord. Now, my lord, there were school certificates that were issued which showed that his date of birth, the year of birth was 1993. And according to that, he was not eligible to contest the 2017 state elections, my lord. What happened, my lord, is that they went ahead and they procured a fake birth certificate, my lord. It was issued in the year 2015. The only purpose was that he wanted his son to contest the elections in the year 2017, my lord.
What about the Aadhaar card?
Aadhaar card, my lord, he had.
Are you aware that there is an Aadhaar card? You are not aware.
But
What about it?
in that particular case, my lord,
In your case,
I don't have the Aadhaar card.
that's why we are saying you don't even know your case. When the court is saying take time, come prepared,
Yes.
accept it, have the humility to accept it. You are not even prepared, you don't even know your case. And the problem is, as judges, we come prepared, not like you all. You are not even aware you have an Aadhaar card. There is an Aadhaar card produced by the applicant where the date of birth is shown as 2005. If you go technical in this matter, it should be dismissed in 5 minutes. So many defects. Have a look at the Aadhaar card. How can the person who has sworn affidavit vouch for the correctness or otherwise of the Aadhaar card? How does he know? He belongs to some other family.
One of the affidavit was sworn by the uncle of the petitioner, my lord. Uncle of Anjuma Khan. My lord, let me. Elder brother-in-law. Elder brother-in-law.
Brother-in-law means the brother of the husband whom she wants
Yes,
to marry.
yes.
The Aadhaar is, my lord, annex are 3 at
At
page
age?
54. At page 54 of the affidavit of respondent number 4. My lord, lordship may take it up after vacation if they do not object.
No, my lord, in my humble opinion, there is no necessity of giving dates. The girls being, and a major girl is suffering since more than 3 months. So for that question, Lordship has already seen the order of Honorable Supreme Court in case of Azam Khan's son. Azam Khan's son was not competent to contest the election. Then he,
Mr. Mahmood, we have expressed our mind that unless something else comes out, we are dismissing your petition. Because there are two sets of public documents. One says she is a major, the other says she is a minor. And it is not the birth certificate, but the other card which is available on record. You have not shown anything why we should not accept the other card.
my lord, Aadhaar card should not be accepted in the present circumstances. This is the product of other days, my lord. Aadhaar card has come very lately, my lord. But the thing is this, the school certificate is genuine where she read and from where she appeared in the SSA examination. So that should be treated because this is everywhere, even in government website also, this birth certificate is accepted. This school certificate is accepted. So for Aadhaar, my lord, that should not be believed, my lord. And here they are the young couple, they have got married, their Qazi certificate, they have not challenged the marriage certificate, my lord. Marriage certificate, they have not challenged. So marriage still subsists. So on the basis of.
All right, but we'll hear the matter again after Bihu vacation. You can choose a date before you conclude. There are many matters, many things we are researching on this case. The assistance we are getting is not enough.
No, that may be well, but is there
Sorry?
any fruitful purpose would be served if the matter is.
Otherwise, we have to dismiss it. If we give the order today, we'll dismiss it.
No, there is.
Case has not been made out.
Yes. My
You
lord.
want to order today?
That idea.
No, Mr. Mahmood, you see, there are, how can the girl herself come and file a habeas corpus petition?
No, because.
How can she come and file a habeas
No,
corpus?
my lord, that was reason, my lord, there just somehow she sent a Bakalatana.
Hmm.
That is evident on record. She was asked that I have filed the case. There is no dispute at all. Now, thing is this necessity knows no laws. When she was confined, somehow she managed, she got the Wakalatama, signed it and filed it. So there is no dispute at all. My submission is this, well, that the young couple got married, marriage certificate is there, school certificate is there, and their certificate is doubtful because there is no book number. There is no initial, my lord. But now that certificate has totally no value. So far now value is only the school certificate. Now school certificate has been accepted by all the honorable high courts, Supreme Court, and this website, government website, Assam government website is also says. So my lord, I think we have a better case. However, if your lordship has then next week it may be, my lord. She's actually her health condition is not going well because since more than 3 months she is there. So let after next week any day as your lordship's convenience.
Next week means?
9-10 is
9,
opening.
10 not possible. You argue, we'll conclude it today. We'll pass an order. You argue because we'll go by, if we are convinced, then we'll pass an order on the legal parameters.
Yes, the judgment we have given last time also.
All right.
But what is their basis, my lord? How they can claim a girl that she should be in your custody, who does not want, my lord, even if we forget every provisions of law, can she be sent to the house where she is beaten every day and night mercilessly? This is on record, my lord. On record, my lord, she was.
Yes, heard Mr. M. Mahmood, learned counsel appearing for the petitioner. Also heard Mr. C. Chaudhary, learned senior counsel, assisted by Mr. D. K. Bakshi, learned counsel appearing for respond numbers 4 and 5. Mr. D. Nath, learned senior government advocate Assam, has appeared for respond numbers 1, 2, and 3. We perused the affidavit filed on behalf of the respond number 3. In terms of our order dated 3/1/2023, whereby he has explained the reasons for his delay in appearing before the court on the previous date, that is 3/1/2023. Full stop. On a careful reading of the averments made in the affidavit, And in view of the unconditional apology tendered by the officer, namely Sri Sanjay Sanwal, we accept the explanation and accordingly do not proceed against him for contempt of court by cautioning the officer to be more careful in future while responding to court orders, full stop. Insofar as the core issue involved in this writ petition is concerned, the same pertains to the validity of competing documents furnished by the contesting parties as proof of date of birth of the petitioner. Full stop. According to one set of document, the petitioner is a minor even today, whereas the other set of document relied upon by the writ petitioner, she has attained majority. Full stop. Both the set of document are public, have been issued by public authorities. Full stop. After hearing the learned counsel for both sides as well as upon perusal of the materials available on record, we are of the view that before taking a final decision as to which set of document deserves to be accepted as valid proof of date of birth of the applicant, the matter would have to be heard further. Full stop. In view of the above, registry to list this case again on 19/1/2023 as a fixed item. The personal appearance of the officer in charge, that is the respondent number 3, shall not be necessary on the next date fixed. Mr. Mahmood, we must tell you this, you were not there. You see, if we do not find any clear-cut principle which permits us to accept one document and reject the other, then the girl remains in the home for another 1 year. Please come prepared with that. Because you will say something, he will say something, we cannot arbitrarily accept or reject. Or on emotional grounds, we cannot.
What
do
are
it.
the foundation? What are their foundation? That should be.
They do not have any foundation. You also do not have any foundation.
No, I have foundation.
What is your foundation?
That is matriculation certificate. That is the Supreme Court.
They have the Aadhaar card.
The Aadhaar card is the product of the other devil.
You show us a judgment which says when.
Yes, of course,
Show us the judgment.
definitely, I will.
Show us. That is why we are giving you
No
time.
doubt Aadhaar card is a public document.
Hmm.
But before the initiation of Aadhaar card, this matter, that was perhaps Aadhaar card introduced.
Mr. Mahmood,
So-
please, you are a counsel.
Yes, I will
Please,
satisfy.
please apply your mind. You see, things are not that simple and casual. These argument of yours, it will take me half a
But
minute. to
our
deal
High
with.
Court has a
Listen to
decision.
this. All the documents you have produced and they have produced are all based on information furnished by the parents of the petitioner. All. Was she in a position to tell her date of birth when it was
No,
recorded?
no, her parents told, the first one,
Yes.
her parents told.
This is also her parents. That is also her parents.
No, then Malak, that should be rejected. Then only the high school certificate. Now, Malak, our High Court is the decision. If something is required by the Honorable High Court
Hmm.
and that is produced by the authority, that should be believed. Now, the government advocate was asked to do the inquire this and that. So many reports have come. Every report is in our favor. Now, High Court has asked something and those are produced and those say I am measured. There is no reason as to why this Honorable Court would not believe. I will show this judgment. When something is called by High Court, then that should be believed.
Mr. Mahmood, we didn't want to say this. Why did you come to the court? You have invited the trouble on yourself.
Because I
If
have
you
no
are a
alternative.
measure,
I have
why-
no alternative. I have every night and then I have beaten my.
then
my
you
knee
should
has
have
been
lodged
broken.
an FIR against the persons who are confining you
My lord, I am.
and come to the court to implement the or give direction.
Yes,
to
my
the
lord,
police.
when my right would be violated, then
You
I
have come
no-
to the court saying that I am a measure. You have to prove it.
That is.
That's
so.
the law.
And in our
And if
opinion,
they produce equally probative materials, then you fail. That's
on
the
the
law.
other hand, my lord, lordship would also see the legal side. legal side legal side as well as humanitarian side.
No, humanitarian is another matter. This is a pitch battle fought
Okay, well,
between.
let us not sit here on that day, I will fix.
But
I will.
you please come prepared and satisfy the court, because you are the one who have come to the court. Why have you come to the court saying that I am a major? Then you have to prove it if they contest it.
And the government has produced filed affidavits after affidavit. Everywhere they say she is better. Why your lordship may not believe?
Don't ask these questions like
Well,
this.
logically, can you indicate about the she is in the state court? What you mean?
The corpus bracket victim girl will continue to stay in the state home
For women at Jalikbari.
for women at Jalukbari until further orders. The respondent authorities to provide all facilities to the corpus in accordance with the regulations, including proper medical treatment if and when necessary.
Madam, my humble prayer, no influence from either side will be allowed in the PWC.
No influence means?
Because the boy comes and meets the
No,
girl.
if the rules permit, that will happen. We're not going to, see, Mr. Chaudhary, the problem here is we have to go strictly by edict of the law,
I
correct?
Yes.
So the other day when he argued, we went back and thoroughly checked the record. He did not point out that there was a other card. He did not point out.
Yes.
That is the problem. We can't write orders immediately. Then when we found that there was a other card and the date was there, we tried to trace back what was the material. There is no material in support of your document. There is no material in support of his document. The question is, which document does the court accept? We are not accepting your document, but his document also cannot be accepted. Now, because he has come to the court, he has to prove it. Emotional dialogues will not work. It has to be completely. Can come up with a authority which unequivocally shows that if there are two public documents, one which is older, and if that goes in his favor, we'll accept it. But if he fails to do that, she will continue in the home for another 1 year.
My apprehension as of now is both sides may come to meet her. Both sides may be tries to come. Parents will come, her brother will come. And the other hand,
That will amount to putting her in isolation. We can't do that. He has a right to be influenced. As per the regulation. We are only concerned about her safety. She can go back to whoever she wants after 1 year. At the moment, she is complaining of torture. And he says, stepmother, there is not even a whisper in the pleading. The problem is, we went by what he submitted, and we found that they were not supported by the materials on the court. No, Mr. Mahmood, these are bad things. Don't do it.
Stepmother will be in trouble. That is the.
No, don't do it. Don't make arguments which are not supported by your students. Because we trust the bar. And then we find that these are not correct. All right, that's all.
Before I take your lordship to the facts and the legal position, on last occasion, lordship also requested the learned advocate general whether something can be done. But yesterday I was informed that there will be something, but it may take some time. My only anxiety is, my lord, since classes have already commenced, and as per the statement given by the learned additional advocate general earlier to the occasion, that 3 seats are vacant, and then our qualifying mark was only 93. And the petitioner secured 334, 291, 218, 212, 201. Now, since only 3 seats are available as on date, let's see the provisional application allowed to attend class. And regarding other individuals, 3 seats are available in which department? No, Madam, MBBS. So, let us be get provisionally, my lord. There are 5 petitions. You are saying
initially there was an order for 34. This down to your 5, you will be subject to the authorization. That's why there will be parties. Yes, there will be no parties. In the meantime, it was informed, peace is got written. That's why we came from the 5. Peace is got written. That's why we informed the court that peace is. So even without disturbing that 5 minus were down to you, things can come. That part is difficult from my side. No, it's not that we are not on session. Yes. No, it's a matter of a week. I think they said a week matter. So I think if they take a decision regarding about the open category, because I informed them, the open category you cannot distinguish, and they made 4%. 93 is a general ST, and in open category both they have kept an ST, inclusive of MISO and non-MISO ST and MISO ST. If that is gone now, automatically they will get that also I think that's why I'm saying without disturbing the 5, who has been brought on record now, then see there are 3 records. This serially goes up secure higher marks. Let us be progressing at the Java take account. Basically, I have to benefit of attending classes. Privacy is a good case because it's a case covered where lots of people can judgment of the where a similar classification of where to be done. I understand my learned friend may have some difficulty in succeeding. You can go by order of the that statement is there from the state side, but 3 receipts are written from my side because 3 says has been kept vacant. We secured with 3 6. Anyhow, but classes are comment. Yes, and it's a minor technical course, minor a medical. Now I have told education, but it was fine. So office, my word is now also we could be fine because the inertia of movement is going to say, my lord, what we call dry skin. At least Mr. Das is not you won't try and wait. Accommodate the 3 in order of yes, 3 petitioners, 3 out of the 5. And that will be a temporary measure. That will be subject to the father. Yes. And your also will father order. Also will not take my consent as a.
And the council appearing for the writ petitioners in this batch of petitions. We have also heard Mr. D. Das, learned Advocate General, State of Mizoram, assisted by Mr. A. Kalita, and Mr. H. K. Das, learned Standing Counsel,
No, well, he's for the private respondents who have been.
and Mr. H. K. Das, learned Counsel appearing for the private respondents. Full stop. The core issue involved in this writ petition revolves around the claim of the 5 writ petitioners seeking admission into the MBBS course in the institution, in the one institution, which is the institution?
Mizoram
State quota.
There's a college to college.
3 colleges, 3 to 4 colleges.
In the medical
by the
colleges run by the state of Mizoram. Full stop. According to Mr. Chaudhary, the case of the petitioners is covered
Yes,
under the judgment and order
dated 22/2/19,
22/2/2019, passed in which page? is it?
PIL number 49 of 16, page number 60, my lord. And the operative portion is at 71.
Page
Para
number-
19, my lord.
Page number 60, you said?
7, no, it starts at 70. The operative portion is at page 71, para 19.
In PIL number 49/2016. Full stop. Mr. Chaudhary submits that the writ petitioners belongs to the Chakma community,
Which is a recognized scheduled tribe.
which is a recognized scheduled tribe in the
State of Mizoram.
State of Mizoram. And therefore, they will be entitled to the benefit of quota of the state reserved for the ST category candidates, full stop. Mr. Chaudhary, learned senior counsel for the petitioners, has further argued that 3 seats in the MBBS courts at present is going vacant. And since the classes have already commenced and the petitioners have a strong prima facie case, an interim order be passed directing the state to provisionally allow them to attend classes, which will be subject to the outcome of the writ petition. First of all, the learned senior counsel for the petitioners has also fairly submitted that since there are 5 writ petitioners and only 3 seats are available, hence the top 3 in order of merit be accommodated, in which even his clients would not have any grievance. First up, Mr. Das, learned AG Assam submits that
AG Mizoram.
AG Mizoram submits that the government is examining the rules
Yes.
Yes.
and therefore, at this stage, it cannot be said whether any amendment to the rules
Yes.
would be brought in near future. However, the learned AG has not denied or disputed that the classes in the MBBS course has already commenced for the current session. Full stop. Mr. H.K. Das, what is your submission?
Only 1 second, my lord. The in order of merit, your lordship will kindly give the name in order of merit.
Yes.
I'll give that. One is Monica Devan
Monica
Chakma,
Devan Chakma,
330 plus,
Hmm.
Renki.
Tongchaya.
No, we'll come to it. Just a minute, just a minute, just a minute.
Yeah.
What is your submission?
We are protected, my lord. We have nothing to say, my lord, with regard to these 3.
At this stage, my lord, they are not.
Mr. H.K. Das, learned counsel submits that his clients are already protected under the order of this court, and therefore he would not have any objection if any interim relief is granted to the petitioners. Full stop. We have considered the submissions made by learned counsel for both the sides. We have also gone through the materials available. Stop. It is not in dispute that the classes of the MBBS course for the current session has already commenced, and there are 3 vacant seats available at present. First up. Therefore, if 3 out of the 5 petitioners are accommodated against those seats, no prejudice will be caused to either side in the matter. Stop. On the contrary, if the seats go vacant and eventually the petitioners succeed in the writ petition, then enormous prejudice will be caused to their interest. Full stop. Therefore, having regard to the facts and circumstances also of the case, and also by balancing the equity, we are of the considered opinion that the present is a fit case where an appropriate interim order is required to be passed. Full stop. There is consensus at the bar that out of the 5 writ petitioners, the following is their
Yes.
standing in
My
order of
lord, my junior will give, my lord. Monita Devan Chakma, 334 marks.
Monita Devan Chakma, 330.
Renki Tongchaya, 291.
You write it down.
I'll write it. And Harisha,
In order
Chakma.
of merit, that is marks obtained in the entrance exam.
yes,
Is it?
neat,
In the
neat,
NEET, N-E-E-T.
NEET.
Stop. Past 5 names will come. Since there are 3 seats vacant, the top 3 would obviously be entitled to consideration at this stage. Full stop.
That will be subject to further round.
Yes. Issue notice of motion in all the writ petition, returnable on, when do you want it, Mr.?
They've already filed affidavit, state and
Filed
other side.
affidavit.
Returnable on, when, 27th? Or
Okay,
should it be 30th of January?
Yes, sir.
30th of January 2021, since all the respondents are represented, and the affidavit, the respondents are represented, no formal notice is required to send in this case. The official respondents have filed their
Everybody, my
affidavit.
lord, all have filed.
The parties have exchanged pleadings, therefore, an attempt to be made to dispose of the writ petition on the next date fixed. First of- As an
31, my
ad
lord.
interim measure, it is hereby provided that the writ petitioners, namely 1, 2, 3, give the name in from the serial.
That my
Be-
junior will
Be
give.
provisionally permitted to attend the
Class.
classes in the MBBS course, which would however be subject to final order that will be passed in these writ petitions.
Deeply.
Sure.
What's up? Harshita, 218. Deeply obliged. Did you?
Sorry, your lordship, I see.
Would you also please jointly check it because
Pass.
not for anything, we don't want a mistake to happen. No,
No, what we'll do, my lord, we'll give the name of 5 with the marks. First 3 you will take out. Devan,
no, first
No,
three.
no,
you
first
read it
three,
all.
yeah. First three,
Mr.
let's complete
Kalita
that.
can also have a look at the.
Yes,
you
yes.
also have a look at the- We are doing